Testing, testing, 1, 2, 3. This is the test of the Seventh Circuit Court of Appeals. Testing, 1, 2, 3.
It's on today's calendar. We'll begin with appeal number 23-1175, Edgewood High School versus the City of Madison. Mr. Strite, good morning.
Good morning, and may it please the court. There's no dispute that the City of Madison treated Edgewood High School differently from other schools with the same zoning classification. The city prohibited Edgewood from using and lighting its field to the same extent as other schools zoned campus institutional district.
I'm not sure I agree with that first sentence that you uttered, because Edgewood, when the new zoning classification, campus institutional, was instituted, chose to put together a master plan. And some did and some didn't. I gather that the point of the ordinance was to alleviate some of the burdens that the status quo ante had imposed for conditional use permits. So maybe some people thought, we'll live with the burden, and other people didn't. But I'm not sure that Edgewood was treated differently from anybody else that had a master plan, for example.
Well, I think there's 2 points that I'd like to make on that. First, with respect to the field use, that was an existing use. Edgewood had had a field since 1923.
And Edgewood can still use its field.
Well, Edgewood was prohibited under the...
No, they were using their fields. When you say field use, you are actually saying nighttime field use.
No, Edgewood, under the Campus Institutional District Ordinance, which went into place January of 2013, established as of right that any high school, including Edgewood or the public schools, had a right to use their athletic fields for athletic contests and other activities related to their primary mission.
That's where the master plan comes in.
No, that's just the CI district ordinance that predated the master plan by at least a year. So what ended up happening is, under the CI district ordinance, there was no restriction on when you had a right to host athletic contests. There was no limitation on day or nighttime uses. So Edgewood had, going into the master plan, an existing right to use its field at night, just like all the other public high schools. This wasn't some type of...
No, I understand that, but the point here is that Edgewood chose to describe the uses that it was currently having for that field as team practices. The actual quote is, used for team practices, physical education classes. And the question then becomes, is what you're now doing an expanded use? And it's my understanding of the record is the city never bothered you about daytime uses. They said, well, maybe this is a technical problem, but we're not going to do anything about it.
Well, no, by choosing to identify examples of how the field was used, that's all Edgewood was doing. The master plan had nothing to do with the field. The master plan was put together to get a consolidated expedited review.
Well, it had everything to do with all of what Edgewood was doing. Let me ask you this question. Suppose Edgewood had been one of Madison's public schools, not a parochial school, and everything else that happened. Same master plan, the same district, because obviously the ordinance applies to both public and private entities. We know this from the University of Wisconsin, for example. Wouldn't everything be the same? The city would have done the same thing. I'm having a huge amount of trouble discerning any element at all of hostility to religion or different treatment of religion. Religion seems so beside the point to me in this case that I need some help from you to show where it is.
Sure. There's no requirement that either under the substantial burden provision or the equal terms provision to prove religious animus. If we have that evidence, it certainly helps.
Well, how about even like difference of treatment because of religion? There has to be a causal connection.
No, all the equal terms provision provides is that a religious institution must be treated on the same terms as a non-religious institution. Sorry, Your Honor.
I'm not really getting this point across well. You, I believe, think that it's actually not permissible to treat religious institutions differently, even if there are different facts, even if there are different things. All you have to do is say, we're religious, and then you're exempt from all laws, it seems like, is your view.
That's not my view at all. The River of Life equal terms test asks equal with respect to what? The campus
And
institution.
you don't think there needs to be any connection to the religious character of the school? It could be religious, non-religious, anything.
No, I mean, in order to make the claim, the institution has to be religious.
No, but where does the religion come in to the actions taken by the governmental entity?
If you can show that a religious institution is not being treated equally, you don't need to establish proof of malice or targeting or anti-Catholic animus behind the decision. It can be inferred from the fact that you have a set of standards that apply to the public schools that don't apply to the Catholic school.
Is there any other Catholic school in Madison?
This is the only Catholic high school in the campus institutional district. So that's why it's the relevance is this is the only Catholic high school. It was rezoned campus institutional district just like the public high schools. They enjoyed all the same land use rights. They enjoyed the same right to put in lights if they satisfied Madison's generally applicable and technical outdoor lighting ordinance. What changed is that all of a sudden Madison decided that Edgewood had somehow forfeited all of its existing rights. This is not a new institution trying to establish itself. This institution dates back to 1881. It's had its field since 1923. And for the city of Madison to just come to Edgewood and say, you've actually lost your right to host athletic contests on your
What do you
athletic
think?
field.
Is that the right that you think has been lost to host athletic competitions?
That's not the right. No, it's the right to use our field in accordance with what the rights that were already permitted under the CI
Use your
district.
field when, where, and how?
Just like all the public high schools.
No, that's not a good answer. At what time, in what ways, all day long, 24 hours a day, you could host a football game at 3 a.m. What are you actually complaining about? Because sometimes when I'm reading your brief, I think, you're making kind of a hypothetical complaint about something that Madison wasn't stopping you from doing, despite the language of the master plan. That is to say, hosting athletic contests during the daytime with no lights. Sometimes I think you're complaining about your inability to get the lights built and used. It's very unclear.
The standard by which we are seeking equal treatment is the campus institutional district ordinance, which set forth the permitted uses. That was all identified. In other words, we had the right to use our field at night, to use our field during the day under the CI district ordinance.
Can I ask the same question a different way?
Sure, please.
Because I don't know that I even understand the unequal terms claim. I don't know what you're arguing. And I think I've read both briefs twice. I can't figure out what you're even claiming. Okay?
Sure.
So it seems to me that the clearest articulation of it comes on page 31 of your blue brief. And on page 31 of your blue brief, as Judge Wood is questioning you, you seem to say that the unequal terms violation that you allege here has two dimensions to it that yes, they relate at some level, but they are independent. The first is using the fields for games. Okay?
Yes.
You say it. I mean, right directly on page 31. And the difficult, as a freestanding claim under that provision. And then, but in your reply brief, at least twice, you come right out and say, but we've always been able to use the field for games. So what I don't understand is, if you have a claim that you are prohibited from using the field for games, but then in the next breath you say, we've always used the field for games, how do you have standing?
No, because that's what the notice of violation said we couldn't do. By stating that we had always had the right, it's an existing right that they...
You never stop. It seems like past tense, you use the field for games.
Correct.
Present tense, you use the field for games. Future tense, you plan to continue to use the field for games. So how is it that the city of Madison has done anything to preclude you from using the field for games when that's exactly what you've done?
No, that's what the city did in 2000 when they issued the notices of violation, which barred us from continuing to use the field for games, which forced us...
And your representation is that you stopped using the field for games?
No, because we had to appeal to the ZBA. We appealed to the Zoning Board of Appeals. We lost that appeal, and then we had to, in order to regain the right.
So what's the injury?
The injury is all of the expenses, the time, the uncertainty, the lost donations, the reputational harm for the city to apply a separate standard to us that wasn't applied under the CI district. This is what ended up happening was.
Okay, now that sounds to me like a claim that we've been given the runaround. It sounds like a due process violation. Maybe, you don't make a takings claim, but I think that what you're arguing is that the unequal terms provision of the statute has been violated.
And it was.
So how do you have How do you have standing?
We were harmed. The notices of violation and the Zoning Board of Appeals affirmance of that Zoning
But
Board
you
of...
never stopped. I mean, you say in your brief several times that when you went to the city, they said, don't worry, apart from this lighting controversy, which is a different aspect of this case, that's item 2 on this page 31 list, the city said, don't worry about it. We're not going to do anything with these notices.
No,
And
the
you
city's
kept
position-
on holding games there. You never stopped having games.
But we had to incur cost, and we were harmed
No,
by...
I don't want to hear about that right now. First, you never stopped holding games, correct?
There were games held after the notices of violation. correct?
Right, so you never stopped holding games. We can have a discussion about the bureaucratic expenditures that you were put to, which is not really an equal terms problem, it seems to me. And usually, there are all kinds of people who fight zoning ordinances. Sometimes a zoning ordinance will say, this used to be acceptable for light commercial use, but now we're going to zone it exclusively for residential, and people might oppose that, or somebody might want to build a church or a mosque or something, and they have to work at it. But if the city has a provision to allow them to do so, then the fact that it's allowed is the important thing. I don't know where in the law you find a right not to have to use the procedures that the city makes available to you.
Well, that's much like the World Outreach case. So the city of Chicago and World Outreach imposed permitting requirements that shouldn't have been imposed on World Outreach. This is the same situation. The city interpreted the master plan to bar us from hosting athletic contests on our athletic. We hadn't.
But they never stopped you from doing so.
That's
And
right, yeah.
do you agree that your equal terms claim that you're trying to allege here based on use of the field is all pre-termination of the master plan? That once you terminated your master plan, that you could no longer argue an equal terms claim based on use of the field?
Right, but for the fact that there's damages that were caused by the notices of violation, which were unlawful.
So when the master plan was in place?
Yeah, both
But
sides.
once that was, I just want to clarify because your briefs are not crystal clear on this. Your equal terms claim, as Judge Scudder pointed out, you have 2 prongs to it. One is use of the field. The use of the field aspect is limited to the time when you had your master plan in place.
Both sides agree that after the master plan went away, then the city's faux obstacle to us hosting athletic contests, the unequal obstacle, was gone. So then we were now being treated on equal terms with the public high schools. But until the city's interpretation was removed, which they wouldn't do unless we repealed the master plan, we had to go through all the cost, expense, and uncertainty of suffering under the city's faux interpretation of our master plan. That's the harm. So to address Your Honor's standing requirement, we were harmed by the fact that the city took the master plan, abused it, and reinterpreted it to treat it basically as a waiver of our existing rights.
So your argument is that you had everything under the CI plan plus district ordinance plus whatever you had in your master plan.
Yeah, a master plan supplements the CI district. That's what it does. The CI district sets forth the baseline standard and is the accepted zoning criterion by which you determine whether a use is permitted or not permitted in the CI district. The
Okay.
master plan didn't change that.
Okay, and you see what you're saying in the courtroom today. You see that as an equal terms claim,
Yes, Your
as
Honor.
opposed to as opposed to due process or takings or something else?
No, because I believe that the standard, again, the accepted zoning criterion asks the key question. Equal with respect to what? The River of Life case clearly says that a religious institution is entitled to be treated equal with respect to the accepted zoning criterion, and gave examples: commercial district, residential district, industrial district. Here, the accepted zoning criterion was campus institutional district. Our claim is that we were entitled at all times to be treated on equal terms with respect to the
So
CI district.
So what's your answer to the city's argument that under this campus institutional new sort of district, it was going to be driven by these master plans, which themselves were enacted into law by the city of Madison? So, you could get rid of it, they could repeal it, but it was supposed to allow for kind of a cooperative public-private process in deciding how expansions of your campus or anybody else's campus, anybody in that field, at the University of Wisconsin took advantage of these things. A lot of districts, a lot of entities may have thought it just wasn't worth the trouble to draft a master plan. You did, though, and while it was in effect, it was the measure of what you had, in your deal with the city, had agreed to do. That's what the city argues in any event.
Right. The city reads it far too broadly. A master
Why?
plan.
I mean, why can't they read it literally? Aren't we told to read the literal words? Literally, you said this is what we're using the field for.
No, thankfully the city even concedes in their response brief at page 29 that it was based on an inference. In other words, we had a picture of our athletic field. It was labeled athletic field. They didn't think that that was sufficient enough to identify that we're going to continue to use it for athletic contests. And then underneath it says team practices, physical education classes. And then they said, well, that was sufficient for us to infer that's all that Edgewood was going to be using its
Right, but if
its
that's
field
where
for.
you're hanging your hat, that's where I go back to what Judge St. Eve was talking about. They never stopped you from having athletic contests. Never.
May I save the...
Yeah, we're going to give you some time. The record's confusing here, very confusing.
I have another question.
I have one. Let me.
Yeah, but no, yeah, sorry.
Here's what really surprises me.
Sure.
That you're focused on a use of property that you never stopped engaging in, as opposed to the denial of the permission to put the lights up. I really thought that we might come in the courtroom today and you would say, forget the games practices distinction. Forget it. Ignore it. What my client is really looking to do is put lights up at the field, and that is at the heart of our unequal terms claim. But you haven't said a thing about lights.
I was trying to address Your Honor's questions as to the use issue. And yes, we maintain our lights claim, and we believe that was unequal treatment as well.
Is that what you care most about?
Well,
Because-
now that we have the right to host games, that is what we care
You never.
most about.
What do you mean right? You never stopped.
No, we were denied that right to harm to the school.
How were you denied it? There is absolutely zero evidence that you were denied the use of your field when you had a game scheduled. I don't see how you could stand here and make that argument.
May I-
There's no claim, for example, that the police padlocked the field.
No, we were threatened. We
People were
received the notices
arrested.
of violation and threatened with penalties under the ordinance.
And you held the
Madison General
games
Order.
anyway.
May I reserve the...
You may.
Can I,
Yeah,
I
please,
know
yeah.
we could give you
We'll
extra
give you
time,
time.
Judge
Don't
Scudder's
worry.
okay. Before you go away, I want to shift real quickly to the substantial burden claim, because I don't understand what you're precisely claiming was your religious exercise at issue there.
Sure. Our religious exercise, you look at the particular religious exercise, the institution has religious purposes for why it needs to use the field at night. We laid those out in our brief. So in other words, we use our field for community and partnership development activities and in order to attract students to the school. That is what the religiously motivated land use is, and under the Religious Land Use Act, you focus on the particular exercise that's being denied. Students are in school all day. Parents are at work all day. We need to be able to use our sole field as a place where we can develop community and
So
partnership.
can you go back to Judge Wood's question then?
Happy to.
Couldn't the public high school say exactly the same thing?
In terms of,
When I read the declaration of President Elliott, he's saying what you're saying, that we need the field at night to develop a sense of community. It brings students, parents, and community and members of the community together.
Public schools can say exactly that, and they have been enjoying, and they have been using their field. The CI district ordinance allowed
But
both.
how's that what's the nexus to the religious mission?
Well, it's integral to the religious mission of Edgewood is to form the whole student, body, mind, and soul. Catholic students are not just formed in the classroom, they're also formed on the field. And we have established, just like the World Outreach case, in which the court said that souls aren't just saved in church, and it recognized that World Outreach's recreational services were a key part or integral part of World Outreach accomplishing its mission. The same way is
Where's
for
the
this field.
limiting principle in that? That is such a broad statement that you could claim you need anything for the use of the field in order to achieve that goal.
No, the limiting principles there are both the sincerity of the religious institution, which is a jury question, but there's also,
No, it's not. We don't peel back claims by religious institutions and ask if they're sincere unless it's something preposterous, like a prisoner saying that he needs filet mignon twice a week, or something. Anyone has seen those cases. But in general, that's precisely what we do not do. So if a religious institution says our religion includes, like the Falun Gong people, exercising every morning, okay, fine, exercise every morning. But I'm searching for a limiting principle too, because I don't see what any of this has to do with Edgewood's religion. I think it has everything to do with wanting a well-rounded program, everything to do with, hoping that it can use the field at night, which is a familiar sort of problem. I cannot see a religious dimension to it because I can't see how any of this would have been different if instead of this being Edgewood, it had been Madison West, for example, a major high school in Madison.
and that goes to the sincerity of the institution.
No, it doesn't. It just goes to whether it has. Not everything that a religious institution does is religious. They hire janitorial services to empty the wastebaskets. That's not a religious act. It's just maintaining a building.
And the line by which a religious exercise, growing a half-inch beard becomes religious or secular is frankly up to the claimant under the statute. And the substantial burden test has to be more than just essentially a judicial Rorschach test. Another limiting principle to Your Honor's question is the fact that if it's just a mere inconvenience on the institution, then it could be dismissed as not substantial. But so long as there is a scintilla of evidence upon which a reasonable jury could find the burden to be substantial, the jury should be allowed to...
How can it be substantial here then when you have access to other fields at night?
Well, the religious, as we pointed out in our brief, the Religious Land Use Act protects a religious institution's right to use its own property in accordance with its religious mission. That was what the holding was in St. Constantine. That's what the holding was in the World Outreach case. And if the Religious Land Use Act was read to allow a municipality the size of Madison or Chicago to defeat any claim by stating, well, we know we're prohibiting you from using your own land, but we have a conference room in our city hall that you can have your mass, or we have a city field that you can use from time to time. You don't get priority, you may be bumped, but take all your students over there, and it may change.
It's the same thing happened to the public high schools, by the way. There are a number of public high schools in Madison that also do not have their own field, who are exactly similarly situated to you.
Well, they're not similarly situated in the sense that they don't have rights under the Religious Land Use and Institutionalized
You are
Persons
being
Act.
treated the same as them.
Yes, and I'm only addressing the substantial burden claim.
Okay, we'll give you some time on rebuttal.
Thank you, Your Honor.
Yep, you're welcome. Okay, we'll hear from the city.
May it please the court. My name is Sarah Zylstra. I, and along with my colleague Tanner Jean-Louis, represent the appellees in the case, which consists of the city of Madison and related entities.
Would you mind starting by doing a quick overview of at least the city's position on how this campus institutional district and the master plans work and how they either are something that build on the pre-existing zoning framework or something that's a substitute?
Well, as this court has recognized, the campus institutional district ordinance came into being because some of the education and medical institutions wanted a cleaner, clearer path to getting their projects through the city. Edgewood, prior to the CI district ordinance going into effect, was zoned residential. That means for anything it wanted to do on its campus, it had to go through the conditional use process, which is an expensive, time-consuming process. The purpose of the master plan was to try and basically identify 10 years worth of projects and to try and get those passed all at once. Now with the conditional use process, that allows neighbors and city residents to come for each project, to make their positions known and whatnot. So the master plan's idea was to have the institution meet with the neighbors and neighborhoods and try and get compromise for the 10 years worth of projects.
So that's the stage at which there was public input. The institution would say, we're crafting a master plan, come to a meeting.
Correct. And the actual CI district ordinance indicates right up front that in several places that it was important to have neighbor input in your master plan. Your master plan, if you did not have any neighbor input, it was very unlikely it would have ever passed the city council, which is what needed to be done.
Where in the text of this ordinance does it support a restrictive reading of the master plan? You've argued in your briefs that if you look at the plain text, that supports your argument that the master plan itself is restrictive as opposed to permissive.
Correct, Your Honor.
But what particular language in the ordinance supports that?
It's two provisions. It's section 28.097 sub 5, and it is the combination of that subsection and 28.097 sub 10. So what sub 5 says is what the contents of your master plan must be. And the master plan must include not only your existing uses, but your proposed future uses during the 10-year period of the master plan. And it's very detailed. It includes land uses and buildings. It includes natural features. It includes open spaces.
But what about that particular language suggests that it supersedes existing rights at the time that they entered into it?
So 5 identifies that you have to identify these things in your master plan. 10 says that you
These things means the things that you are now doing or that you're planning on doing?
both.
Okay.
It has a section for existing conditions and uses and future uses. And capital improvements, open spaces, they are listed both as existing and future uses that you have to identify. Subsection 10 then says that you cannot alter your master plan, and it says importantly, including changes to the proposed use of identified open space areas shall be permitted unless approved by the Plan Commission. It then provides that if it's a minor alteration, then the zoning administrator might be able to approve it. But if the change or addition constitutes a substantial alteration of the original plan, then it says the procedure in 28.0976 is required. What that procedure is basically the approval of the master plan. So you can amend your master plan, but it has to go through the approval process, which again and if you think about it, it only makes sense, right? Because what the city's trying to do is balance the vitality and the neighbor's interest versus development's interests. And so this process brought them both together, and then the master plan becomes an ordinance that if you want to change would have to go through the amendment process.
Is there any hybrid arrangement available? So say, for example, something very unexpected happened that required a capital improvement. And you said, well, it's unexpected, so by definition, we didn't know what to put in our plan.
Correct.
But what we would like to do is go through the conditional use permit process with respect to that.
It would not go through the conditional use. It would go through the amendment to the master plan process, which is similar to the condition.
And is there a way for that to all be expedited to deal with an emergency capital improvement, for example? Like the boiler goes out and you say, well, we want to
Yes.
move away from steam heat.
The city obviously would have to put notice out for that, but they could certainly do that and do that on an expedited basis. And the important thing here is Edgewood actually filed to amend their master plan. They wanted to add lights and a stadium, and the city had said, hey, we think your use is not right in your master plan. Add that to your amendment. Let's just take care of all of these things at one time. Edgewood proposed that amendment to the master plan. and then decided not to go forward with it.
Can I ask you the favor of, kind of in keeping with Judge Woods, just to try to level set this and get the ground stationary in this case? What do you understand their unequal terms, unequal treatment claim to be? Don't argue what your
Correct.
position is. Can you just describe what you think their claim is?
I think they have two claims. One is field use, one is lights. On the field use, their claim is that they, my understanding, is that they incurred the cost of appealing the notices of violation, and that cost shows that they were subject to an unequal treatment of a secular institution.
Okay, even though their actual, in fact, use never changed.
Correct.
So did the city ever in any way withdraw those notices or say they weren't going to issue those notices anymore, or
What
give
this-
them legal certainty that they weren't going to be enforced?
The city attorney sent a letter to Edgewood in telling them that they would not enforce those notices and invited them to repeal their master plan. Edgewood elected to do that, and the city council approved the repeal of the master plan. That put them under the ordinance, the CI district ordinance for those institutions without a master plan.
And that meant that they needed to use the conditional use permit process again?
So this is partly a timing issue. The campus institutional ordinance was amended during this process. The amendment provided that you would go through the conditional use process for modifications.
But that would pertain to the lights, not to the use of the field, correct?
Correct. Once the master plan was repealed, they had full use of their field without needing to go through any
And the
process.
city informed them, or you're representing today, that they can use their field for whatever they want,
Correct.
given that the master plan is no longer in place.
Correct.
So no more notices, no more, nothing else ever happened?
Correct.
Okay.
We have to, under River of Life, look at the accepted zoning criteria.
Correct.
I think you have said it is the CI district ordinance?
It's the CI district ordinance for those with master plans. There is definitely two tracks. You could have a master plan which has benefits, because you could get 10 years worth of projects all passed at once without having to go through a conditional use process.
Why wouldn't that be the accepted criteria, zoning criteria, the master plan itself?
And I'm sorry, I don't understand the question.
As
Your Honor.
opposed to the full CI ordinance, why wouldn't we just focus in on the master plan being the accepted zoning criteria?
Well, it is, Your Honor. For the time period where they have the master plan, that is the
That
zone, that is the accepted criteria, and the provisions of the ordinance that apply for those institutions that have master plans.
And that was very few, right? It was University of Wisconsin, and it was Edgewood, and is anybody else?
There was no other institutions that elected to go through the master plan process.
Yeah, Memorial High School is not a master plan.
Correct. And Memorial High School, turning to a little bit on the equal comparators lights issue, Memorial High School put their lights in the 1970s under a far different ordinances and whatnot. They also elected not to do a master plan, so they are not an equal comparator as to lights. UW faced the same circumstance as to lights. They had put in lights on their tennis court prior to their master plan becoming effective. So that is why they are not equal comparators when it comes to the lights.
Wouldn't they be an equal comparator after the master plan is terminated? If they know, if,
Are you talking
For
about
the lights
UW
only.
or Memorial?
I'm talking about Madison.
Okay, so after Edgewood repealed their master plan, the University of Wisconsin continued with their master plan, so they'd still be subject to their master plan.
I'm sorry, then Memorial, that
Memorial-
wasn't subject to a master plan at all. Once Edgewood terminated its master plan and still sought the lights, wouldn't they Memorial being the appropriate comparator?
They would be, except Memorial's already got its lights at that point. What the comparator would be West High School. If West High School wants lights on its football field, they would have to apply and go through the conditional use process. Edgewood, the same thing. Edgewood went through the conditional use process and was, I say, denied being generous to Edgewood. What the city actually said is, we want you to come back, Edgewood. We want you to it was not a final denial of the lights. It said that the neighbors have brought forth significant evidence of noise and light issues. We want you to do something to try and address those and reapply. Edgewood elected not to do that and instead elected to bring suit.
And I don't think there's any evidence that there were any complaints from the residents about Memorial having lights, correct?
Correct. There's no evidence of the record of that. There's no evidence of the record of any complaints against UW. There were complaints filed against Edgewood, which is what led to the notices of violation.
So is Memorial in an area that's otherwise zoned residential?
So for the Memorial prior to the CI district ordinance was not zoned residential. There is some apartments right behind the Memorial. Those were built after Memorial was there and after the lights were there and after, so there's at least some argument that,
Coming to the nuisance,
yes, as opposed to Edgewood.
So what is the zone? Is it
It was
mixed
zoned-
use or something?
It was zoned at the time Conservancy, which is an odd zoning ordinance district.
Never mind, then don't worry about it.
I would like to address any questions you have, and I'll switch a little bit to the substantial burden argument.
So
How do
I
you-
wanted you simply to reply to the argument that the Edgewood people are making based on the World Outreach litigation and the River of Life
So,
cases.
and I think to do that, and Your Honor, please direct me if I'm going too far afield. I think the first test is to define what is the religious exercise, at least when we
I'd be
talk.
delighted if you would do that.
I find their definition of the religious exercise in their brief in chief at page 49. And Edgewood has never asserted that night football is a religious practice in and of itself.
Jokes to one side, I can understand why they would not
Yes.
do that.
Its religious mission, as I understand their argument, is education, and their argument is that night football games help to attract students. That's what I understand.
Well, the clearest articulation of it comes from Mr. Elliott's declaration, right? And then, I mean, that talks about a sense of community,
Correct.
trying to bring parents, alumni, community members together,
And I agree
all
with
that. I mean, that's what they rely upon.
I agree with that, Your Honor. And my response to that, if that's the court's question, is a couple of things. There's no evidence in this record at all that parents pay any attention as to where an athletic program holds its night games when choosing Edgewood, as opposed to its academic or religious programming as the reason for going to the school. In fact, Edgewood hasn't even introduced evidence that field use generally boosts enrollment. And here's an interesting fact that is in the record. It's undisputed that enrollment at Edgewood actually decreased after they made the upgrades to the field in 2015. And that's at record 58, paragraphs 226 and 227. So there's no tie to field use or night field use actually boosting
So you're just seeing
enrollment.
these as utterly unrelated, no post hoc ergo propter hoc.
What about the argument, though, that it's necessary to develop the whole person, which is important to the religion?
I think that they can develop the whole person through daytime use, through use on the weekends, and
But
even
they've
through
argued
night
otherwise under their religion.
I'm sorry, Your Honor?
They've argued otherwise under their religion.
I think they have made some conclusory statements without evidence, but I turn the
So you're
court's-
saying, if I'm understanding, that even if we accept fully that their mission is to attract and to educate students in mind, body, and soul, as was said this morning and as is in the brief, you can educate people in mind, body, and soul even if the game is in a field across town.
I would, Your Honor. This is the issue is substantial burden, not just any burden. And
That's on the initial question of the religious belief. Is that something we can be determining, as
We're
opposed to
not-
the second part of substantial burden?
We are not challenging the sincerity of the religious belief of Edgewood. But Edgewood doesn't get to offer speculative expert testimony without foundation. And this case, to me, is on all fours with Livingston Christian Church, which is a Sixth Circuit case. And in that case, the principal of the school claimed it needed to relocate the school because its enrollment was dropping and it was losing funds. And in rejecting the substantial burden argument, what the Sixth Circuit said was there's just insufficient evidence. It said the court noted that the school could have put in declarations of parents saying, you know, I would send my kid to the school, but for its location or whatnot. The only thing it offered was the testimony of the principal saying, I believe I need to relocate to increase enrollment. And the Sixth Circuit said, that doesn't do it.
So your position is that, don't let me put words in your mouth, is that we're not in any way questioning the sincerity of their beliefs. Indeed, we'll accept it. But it's too attenuated, even accepting their articulation, for that belief or that set of principles to amount to any kind of religious practice or religious conviction for purposes of application of the substantial burden provision of the statute.
Correct, Your Honor. I think if this court holds otherwise, then any religious institution can say they're substantially burdened by just saying that my religious beliefs requires me to be exempt from this law.
Well, that's where the limiting principle question's coming from, because if there's any land use decision that adversely affects a religious institution and it just ipso facto or necessarily becomes a substantial burden claim, then you've emptied the provision of any content.
Correct.
There's nothing that limits it.
Correct. That is our argument, Your Honor. I just want to jump and make one or two quick points, which, given my limited time left, and this is just to make sure that the court is mindful of certain things that occurred in the reply brief. Edgewood argues in the reply brief that the master plan and the city's ordinance are ambiguous. I want the court to be aware of the fact that in the trial court below, there was no argument at all about ambiguity. It was not in their brief at all. And not only that, but the words ambiguous or ambiguity do not appear in their opening brief to this court. It only appears in the reply brief. So I want the court to note that we believe those arguments are waived. I think I addressed the permissive versus restrictive because I think that's an issue that they have relied upon heavily. I'm sorry, my time is up. Thank you very much for your time and attention.
Okay, Ms. Zylstra, thanks to you. Mr. Strutt, we'll give you a couple of minutes. We asked you a lot of questions and want to give you, a full opportunity to make some points on rebuttal here.
I appreciate it, Your Honor. I'll start with the lights issue. Until March of 2019, the city agreed that the master plan did not bar any off-site plans. That's how we installed $1 million field in 2015. That's how we installed conduit for lighting in 2015. That's how we installed a scoreboard in 2015. What ended up happening was after they instructed us to file a lighting application, just like Memorial had done the year prior, we submitted a nearly identical lighting application, submitted it. It was reviewed under Madison General Lighting Ordinance 10.085. It met all the requirements. Then there was neighbors that found out that we were going to get an approved light permit at the city's direction, and at our we complied because we had already been burned by their reinterpretation of the master plan on uses. So we made sure we got it actually in writing from the city. We complied with those ordinance requirements. And then they became aware of this new interpretation that any plan not otherwise identified in the master plan had to either go through a master plan amendment process. I mean, if you even take that interpretation to its logical extent, Edgewood couldn't replace its boiler, couldn't install a handrail. There was no limit to what capital improvements would require a full-blown master plan amendment. We are here for the lights, and we can get it under the equal terms provision or the substantial burden provision because they went through an entire individualized process that resulted in the denial. Their own zoning staff proposed the conditions that met the neighbors' interests and concerns, that satisfy the obligations for us to mitigate any harms by our night activities, which doesn't just include night football, but it includes night community events, night alumni events, where we have one field, 21 teams, alumni events, and a lot of things we need to do in order to attract students to our school, sustain enrollment, and put forth the Sinsinawa Dominican values.
Okay, very well. Thanks to counsel for both parties. The court will take the appeal under advisement. Okay, our second argument of the morning is in a series of consolidated appeals. The lead one being 22-26-36. This is Latanya Cannon and other plaintiffs versus Armstrong Containers and other defendants. Yeah, Mr. Bograd, we're going to begin with you. Good morning.
Good morning.
May it please the court, Louis Bograd for appellants Latanya Cannon et al., along with my colleague Fidelma Fitzpatrick, who will be handling the rebuttal this morning. In Thomas X. Earl Gramling versus Mallet, and I know this panel is very familiar with these cases, the Wisconsin Supreme Court held that victims of lead poisoning from residential house paint could sue manufacturers of white lead carbonate and invoke Wisconsin's risk contribution doctrine, which permits liability even when the plaintiff cannot prove which manufacturer made the WLC that injured them. In Gibson, this court upheld Thomas's application of risk contribution against numerous constitutional challenges. Then, in Burton, this panel limited the scope of liability under Thomas, but expressly contemplated that there was still a route for plaintiffs to recover, as it clarified multiple issues for future trials. Yet, on remand, the district court held that various preclusion doctrines applied and prevented all of the plaintiffs, including nearly 150 plaintiffs who have never had an opportunity to litigate the issue, to proceed with their claims. This was clear error and must be reversed. Let me start with first principles. As this court said in the opening sentences of Tice versus American Airlines, and I believe, Judge Wood, you wrote that opinion, it is a fundamental principle of American law that every person is entitled to his or her day in court. Multiple victims of air disasters, multiple stockholders of companies that have committed security violations, and multiple holders of rights and pensions normally may all bring their own suits,
Right.
even if the defendant engaged in a single course of action that affected everyone similarly.
So let me pick up with that thought, since obviously our court's decision in Tice was far from the last word on these things. The Supreme Court's decision in Taylor against Sturgill is my starting point these days. And in that opinion, Justice Ginsburg lists a number of ways, and I don't read this as an exclusive closed list. She lists a number of ways in which prior litigation can be held to be conclusive against somebody in a later bit of litigation. It didn't happen to work in Taylor, but this case is really important and interesting to me because it really raises the question, when there are formally consolidated proceedings, there was a single case management order here, there were a lot of people were joined under the Rule 20 joinder provisions. It really, to me, implicates what happens actually with the entire MDL process, even though this isn't quite that. But there are ways these days that courts are managing closely related cases, and it looks to me like that's what this might have been. You know, it looks to me like here you have, you know, a single representation raising related claims, careful decisions of which wave of cases is going to go first and which wave of cases is going to go second. So I want you to tell me why Taylor doesn't understand this tight coordination of litigation as something that belongs in that list of exceptions.
Your Honor, I'll be happy to answer that question. I think it's important, however, that we distinguish between the three groups of appellants before you to understand these questions, because the appellants are not all similarly situated.
Right.
In our brief,
There's
we
some
refer to
differences.
them by group number.
Right, which is fine. You know,
let me
it's wave
just-
1, wave 2, group 3,
Right,
group 4.
but just so we're clear, the Gibson
Yeah.
and Vallow plaintiffs are three plaintiffs who filed their own lawsuits. Those lawsuits were never consolidated in any way formally with any of the other existing cases.
But they're
That's your
being
wave
managed
4,
by
right?
Judge Avery.
They're being managed collectively.
under the
There's-
same case management order.
Yes, although with multiple captions on the case management orders, but yes, absolutely. No, in these cases, the analogy that you made to the MDL is exactly right. This is essentially like an MDL.
But isn't it different than an MDL? Because the MDLs in the mass tort area, which is where you typically see these bellwethers, they are generally all individual cases that are consolidated for pretrial purposes. They are not cases where all the plaintiffs have joined together in one complaint, which I appreciate your distinction of Wave 4 because I do think that differentiates from the other cases here where, despite the defendant's efforts to try to make these individual cases, you wanted them all in one complaint in one case.
Well, Your Honor, I mean, there's a historical reason why that happened, but you're
yeah.
right. But there's no question that Group 3 is differently situated from Group 4.
And from MDLs. I mean, your point was this is similar to MDLs, but I don't see this as similar to MDLs procedurally because the large MDLs are hundreds of individual cases. That is not the situation here.
Well, it is certainly the case that in this case, Group 3, the Group 3 plaintiffs all joined on two unique complaints, the Allen and Trammell complaints, and that's to that extent they were part of the same case.
And that surely is important. I mean, if you have Rule 20 joinder, I don't see any rule that says you wouldn't apply issue preclusion.
Well, there's the critical distinction, Your Honor, is that under the case management order, even though in some sense Allen and Trammell were each one case, the judge's case management order said the parties will now select 8 cases from which we'll then pick 4 to be Wave 2.
Right.
And he used the word cases there as well, but we didn't pick all of Allen and all of Trammell and 150 different plaintiffs. We picked 8 individual people,
right.
And only those 8 people went forward with discovery. The other 150 people were essentially stayed. Their cases, their claims,
But there were
whatever
agreements by you in the case management order that the common issues the resolution would apply across the board, which is why this was such an efficient way of handling it.
There was an agreement that the court could extend, and in fact what the court typically did was one side or the other would ask the court to apply apply a ruling across the board, and then the court would decide whether it was appropriate or not. And in that regard, I think it's important to distinguish between 2 separate moments in this case. When American Cyanamid said, you found that there's no personal jurisdiction over us, apply that across the board, the judge said, well, that's a pure question of law. There's no reason for me not to apply it to all these cases.
It isn't really, though. I mean, all sorts of facts underlie a finding of lack of
I don't disagree with you, Your Honor, but that's the way he characterized it. By contrast, ARCO, which in the very first trial, the Burton trial, had been held not liable by the jury, ARCO filed a motion and said, this should apply to us in all of these, to all these 150 cases as well. This is, I'm sorry, I'm trying to find my notes. I think it's Allen docket 447. And the court said, no, that's not right. In mass tort cases like this, courts recognize that the party's evidentiary treatment of the issues is likely to become more focused and thorough with reiteration, and therefore hesitate to apply issue preclusion after only 1 or 2 trials. The situation here is exactly the same. The plaintiffs, leave aside for the moment, the 4 plaintiffs who filed who dealt with, and I should note, the summary judgment motions at issue here, when they were first filed, were only filed in the cases involving those 4 named plaintiffs. The defendants specifically captioned them to apply only to those 4 named plaintiffs. The plaintiff's response.
This is the Wave 2 summary judgment?
The original Wave 2 summary judgment while this panel was considering Burton. The Wave 2 summary judgment, the motions were styled as applying to only these 4 plaintiffs. The responses was specifically said, we're responding on behalf of these 4 plaintiffs. And the ruling was expressly limited to these 4 plaintiffs. It was only later, after Burton came down, now you say we sought consolidation, and in some ways we did, and the defendants opposed, in some ways they did, and we opposed. I mean, each side...
I didn't say you saw consolidation. You filed it as one joint, very large complaint.
We definitely filed the one complaint at the very beginning. But so after this court's decision came down, we went to the court when the defendants said, okay, now apply summary judgment, apply issue preclusion or law of the case or whatever to all of us. We said, Your Honor, that's not right. We didn't, all of Group 3 and all of Group 4 did not participate in that motion. They were under no notice that it was going to apply to them. They have not had an opportunity for discovery. They did not have an opportunity to participate. Give us discovery so that we can prove the evidence that this panel said we need to prove to win the case.
But did they implicitly agree to that with all of their representations in the case management order and other representations to the court?
Did we
implicitly agree to be bound by
No,
it?
I don't believe we did, Your Honor. In fact, I don't think there's anything in any of the case management orders that ever says, this was not like a master consolidated complaint in an MDL situation where the judge said he was going to rule on common issues and apply them to everybody. I direct the court's attention to the Home Depot case from the Third Circuit, which I think is really instructive in this regard. The facts are a little funky in that case, but the court's basic message, which is that individual cases in an MDL retain their individual identity. And we also quoted in our brief the Judge Fallon's law review article about bellwether trials. The reason you hold bellwethers is that both sides learn about the case.
But again,
and are in a position
procedurally, that's different because you're dealing with an MDL proceeding where you have individual cases. And in the Home Depot case, they even recognize that cases centralized in an MDL retain their separate identities unless they choose to proceed on a consolidated master complaint.
No question, Your Honor.
Which is kind of what we have here, master complaint.
No, Your Honor, it's what we had here when the complaint was filed. It's not what we had here after Judge Edelman said, I am selecting these 4 cases to be my Wave 2 bellwethers and allowing those 4 cases alone to proceed to discovery.
So you're saying that's a severance order, essentially?
Yes, we called it effective severance in the motion. And if you read my colleagues on the other side said that we didn't make that argument below, that's absolutely wrong. We didn't use that terminology, but we specifically say in opposing summary judgment below that that the summary judgment motions were styled as motions against only the 4 plaintiffs, that they were litigated only by the 4 plaintiffs, that none of the other plaintiffs had any understanding that they were being represented virtually or otherwise. I mean, and there were no special protections put in place in order to protect their interests.
So you're principally talking about non-party issue preclusion. That's what these arguments most directly apply to.
No, I think not, Your Honor. I think they applied a non-party issue preclusion as to the Gibson and Vallow plaintiffs.
Group 4, Wave 4.
Group 4.
Yeah.
But I also think they apply to Group 3 because when the judge said, I'm going to take LaTanya Cannon and these 3 other plaintiffs and pull them out and make them the next cases for trial and let them go through discovery and have dispositive motion practice as to them, that separated them from all these other cases. And
can issue preclusion...
I'm sorry, Your Honor.
Can issue preclusion or claim preclusion even apply to the Group 3 plaintiffs, given that they are all part of the same complaint? Because typically issue preclusion comes in a subsequent case.
You're right.
There's an exception for collateral issues, but nobody's arguing this is a collateral
well,
issue.
I think issue preclusion can't apply to the Group 3 or to Group 4 because there's no privity. These are not... These plaintiffs do not have the same legal claim, the same legal interest as the Wave 2 plaintiffs who litigated the case. But I want to go back to Home Depot.
The basic principle which Taylor reiterates, that
Exactly.
every person gets his or her day in court.
But I want to go back to Home Depot for a second, because I think Home Depot really explains what went wrong here. At the end of Home Depot, after the court says issue preclusion in law, the case can't apply on these facts, they say that's not to suggest that judges managing a complex litigation don't have tools they can use to manage these cases efficiently, and we commend them for being creative and efficient. One tool they say explicitly that they have is the order to show cause. That one thing that you can do once you've rendered a judgment in cases of only a limited number of plaintiffs is then you can say, well, it seems to me this principle should apply to the other plaintiffs as well. So
That's one tool, but that doesn't mean you have to use that.
But it is the tool that protects the due process interests of the Group 3 and Group 4 plaintiffs, because those plaintiffs then get to say, Your Honor, no, here's why that shouldn't apply to us, because under this panel's decision in Burton, we can still win if we can show you that contemporary consumers were unaware of some of the hidden risks of lead paint, specifically the risks of lead dust. And here we have 1,500 pages of evidence, documentation, expert reports, affidavits from the plaintiffs, et cetera, that we were not fully aware.
Can I interrupt you there? We're going to give you some, don't worry about it.
Okay.
Okay, this
Thank
is
you.
very complicated.
I'm mostly concerned about my colleague and her rebuttal.
She need not be concerned.
All right.
She's going to get rebuttal.
Thank you.
Okay. Can I focus you specifically just to get the benefit of your reaction to this dialogue, to the Wave 2 plaintiffs?
Yeah.
Okay. The Wave 2 plaintiffs, and in particular the summary judgment ruling, and the district court's emphasis on what it viewed as a concession. Because I think the effect of that concession, I don't want to quibble with words here, but the effect of that concession was the district court saying that the Wave 2 plaintiffs basically threw the towel in. They acknowledged that they didn't have any kind of unique evidence to offer, on the duty to warn claim and the timing issue embedded with that.
And Your Honor, we've contended in our briefs here that they should have been given the opportunity to reconsider that position after this panel's decision.
Okay, here's what was that position though? This is my specific question. Was that position accompanied by any evidentiary proffer? In other words, I know it is now.
No, it was not, Your Honor. Those 4 plaintiffs said they looked at the district court's earlier ruling.
The Wave 1 ruling?
The Wave 1 ruling.
Right.
And they said, based on this Wave 1 ruling, we know we can go to trial on what, and as we've said on the substantive side of this case, which we're obviously not talking about right at the moment.
Right.
But on the substantive side of this case, we said that that we thought the Wave 1 ruling was correct. We still think under Wisconsin precedent it should have been correct. That the real issue was what did the consumers know at the time the paint was sold back in the 30s. And they made the decision, and it may have been a mistaken decision, to not fight the application of the summary judgment on negligent failure to warn.
Okay.
Those 4 plaintiffs. But that's why I think it's really critical as we discuss this case to distinguish the situation of those 4 plaintiffs from the other 150 plaintiffs who never had that opportunity to decide.
The non-participating Wave 2 plaintiffs, the ones that did not participate in that summary judgment, aren't they
what
bound?
we call Group 3.
Group 3, aren't they bound by that concession?
Why?
It's part of the exact same case.
But they didn't make the concession. The motion was filed against 4 plaintiffs. The opposition was submitted by 4 plaintiffs.
Yeah, but those 4 plaintiffs that are joined under Rule 20, properly joined, right?
Yeah. But the judge had said repeatedly, we're going to have multiple trials, multiple proceedings, multiple whatever. You're essentially saying that those 150 people who were not even allowed to file briefs on they weren't party to that motion. To say that those people are somehow bound by a concession that 4 people made in a particular moment in time, in a particular legal context, that quickly ceased to be the applicable legal context after this panel's decision came down in Burton. It's just, I think, as a matter of due process, those other 150 plaintiffs should have had the right, as Judge Edelman initially said when he agreed to give them discovery, they should have the right to meet the standard this court articulated in Burton. And that's what we attempted to do. We submitted 1,500 pages of evidence, and the court just said, well, I don't really want to look at it. I'm just going to hold that you're all precluded and send you home.
Okay, let's hear from the defense side. We'll come back for rebuttal then.
Good morning, and may it please the court. Lee D. Julius of Jones Day on behalf of the appellee, the Sherwin-Williams Company. This is a case where the plaintiffs got what they asked for. As Judge Edelman indicated, he jointly administered these cases for over a decade. Plaintiffs brought more than 150 cases under Rule 20 jointly in one case caption and one case, and they asked through CMOs to have issues decided once. And I quote, and this is at DSA 53 to 54 of the record, Your Honor. Plaintiffs said that threshold legal issues should be decided once and not on a case-by-case basis. Judge Edelman granted their CMO request and entered it in every single one of their case, every single one of these cases. Likewise, defendants brought a motion to sever, that 150 cases that came together. Defendants filed a motion to sever. In their opposition, and this is at DSA 14, plaintiffs said the failure to issue precautionary warnings is one of the numerous questions of law or fact that are common to the plaintiffs.
Can I ask whether you are talking about only Group 3 or whether you're also including these small number of people, 3 people in Group 4, who did file separate complaints, no Rule 20 joinder? They seem differently situated.
Correct, Your Honor. And they are...
So you're not talking about them right now?
Well, when I'm talking about the CMO, that was in all of the cases. That included Vallejo and Gibson. So the individual cases, they asked for a CMO to be entered in every one of the cases, and that CMO was entered.
But
As far as the
are you
severance,
arguing that a CMO is the same thing as some kind of Rule 42 ruling? I mean,
Well-
cases are managed separately all the time, and they don't become separate cases. And I guess one of the things that worries me about your position, just to jump to the chase, is the following. For purposes of non-party issue preclusion, it's possible to go one of two ways. You could go the functional way, which was what the virtual representation doctrine tried to do, or you could go the relatively formalistic way, which is what Taylor chose. Taylor expressly disapproves of this kind of, hey, it looks like all on the facts and circumstances, you guys are on the same page. And they certainly were. If you look at the facts in Taylor, these are not people who are strangers to one another. They belonged to the same associations, they were raising the same claims, they were in many ways identical. And nonetheless, the court takes a formalistic approach. And so when I look at what we're supposed to do here, that's maybe the first question I ask myself. Do we take a relatively strict formalistic approach and say there were at least certain people here who did not have their day in court and they're entitled to it? Or do we take kind of this more touchy-feely, functional approach that the court seems to have disapproved in Taylor?
Well, I don't think the court needs to answer that question here, because what we have is a CMO that governs all of the plaintiffs. All of the plaintiffs
But that's
ask
why
for
you're
the
saying,
CMO.
you're saying the CMO is a consolidation order.
Well, what I'm saying is, if you look at Taylor, Your Honor, footnote 7 specifically says in Taylor that when can you have non-mutual defensive issue preclusion? When you have an express or implied agreement to litigate the cases together, when all of the plaintiffs litigate together. That's Taylor. When you look at the Home Depot case, the Home Depot case expressly says when you use CMOs, judges should use CMOs to bring issues together, to have issues decided once. That's exactly what we have here. And that's
But do we, for Group 4 in particular, I want to focus on the same group Judge Wood is pointing out. You have the one CMO where they agreed that there are some threshold legal issues that will of course apply to all cases. And it seems like in the 6 factors that Taylor identified, that in terms of agreement to be bound is all you have to hang your hat on. That one CMO for group 4 where they said certain issues would apply to all.
Well, what we have, Your Honor, is after that CMO, the judge applying it, and applying it to non-issue defensive issue preclusion. And in the case of American Cyanamid, it dismissed Cyanamid from every single case after Burton 1.
But that seemed to be pursuant to a particular agreement about cyanamid, just this personal jurisdiction issue. It didn't seem, I didn't read it as just this wholesale agreement for everything to be, all for one and one for all.
Nor did I.
No, well, Your Honor, what happens in Cyanamid is in the motion to dismiss, it was filed under
Well, I
every case.
remember what happened in cyanamid, but I'm saying how much do we leverage that out to the rest of the case?
Because what happens is the plaintiffs were on notice at that point that this issue preclusion wasn't going to just apply to defendants, which is what the plaintiffs really wanted
But
it
it
to do.
has to be more than on notice. They have to, under Taylor, they have to agree. Either explicitly or implicitly.
Or implicitly.
And I'm focused on group 4 because they're not part of the complaint that wave 3 is. They're not arguing all along, we don't want to sever, we're going to stay the same. And the only evidence I see in this record that they agreed and it would be explicit is the one CMO that we've been talking about, where they say there will be some issues that will cut across everybody and it's more efficient to do this. That seems under due process like a lot to hang your hat on, that they're going to get their day in court based on
But Your
that.
Honor, there's a sequence of events. So in 2019, American Cyanamid is dismissed for every one of these
Take
cases.
that out.
I
because
understand, but
I see that. Take that out because I don't see that as the plaintiffs in wave 4 conceding that everything is going to apply to them.
I hear you, but the sequence here is important because that happens in 2019. Burton comes forward. The wave 2 plaintiffs come into Burton and they say, we're not going to relitigate any of the issues that were decided in Burton 1. We don't contest any of those. Then at the same time, while that case is pending, and mind you, we asked the court and we asked the plaintiffs to stay all further proceedings. Let's find out what happens in Burton 2. And all of the plaintiffs said, no, we want to move forward with more cases. We want to press forward. It was their litigation strategy
Wave 4
to go
didn't
forward.
move forward.
Yes, they did.
Not with trial or summary
They
judgment.
objected to the stay. They objected. Wave 4 objected to that stay and
So
said
they
we
move
want
forward
to move
with
forward.
discovery. That can't bind
well-
them to decisions in a summary judgment.
But Your Honor, and then there was another CMO request that Wave 4 joined that said we want more plaintiffs. And again, they said, and this is after Burton 1, to decide issues once. That we think, in fact, now that we've had a trial and now that we've had Wave 2 go through discovery, we think we can bring more plaintiffs on and we can do it faster. So to suggest that the Wave 4 plaintiffs weren't active participants is not correct. Did they
Active
get discovery?
participant
No.
is different than what Taylor says for due
Correct.
process is required, that you need an agreement, either explicit or implicit.
Or implied, or
And
through conduct.
It seems like you're hanging your hat on an agreement for the Wave 4 plaintiffs based on the CMO that I'm having a hard time seeing as an implicit agreement to be bound by summary judgment rulings that were filed in a different case that they're not part of.
I understand, Your Honor, but that was the intent of the CMO. And Judge Adelman, who entered the CMOs, who heard the parties, who was part of the process, is entitled to some deference on how he interprets those CMOs, what was going on
But we
on
can
the
read
ground.
the CMOs too. I mean, I think you're putting some interpretation on how far they're going to go. We know there's some coordination. Nobody disputes that. But I think Judge St. Eve is pointing out that Taylor, with respect to the right of each person to have their own day in court, is saying consent.
But that's what we
Consent
have
to
here,
what?
Your Honor.
Consent to joint discovery? That's not the same thing.
But there's not every plaintiff participates in the same way in the case. And what the plaintiffs did in this case through the CMOs is identify, yes, we're going to have representatives. Those representatives will have discovery. Those representatives will have trials. And in that same document, and those threshold legal issues will apply to everybody.
What's the best legal authority you think you have? The husband-wife Jensen case?
Well, Jensen demonstrates that non-mutual issue preclusion is defensive issue preclusion is acceptable under Wisconsin law. That it is a thing. I think
least
that
on
you
that
look at
fact
With a
pattern.
fairness overlay, though, Wisconsin does have a two-part test.
yeah, absolutely, Your Honor.
And that doesn't answer the federal due process constitutional
Well,
issue.
yes,
The Taylor.
That's fair, Your Honor. But if you look at Taylor, which does recognize that there are instances where you can have non-mutual issue preclusion, including implied agreements. In this case, I would argue it's express, where they say we're only going to decide things once. And then you also look at Home Depot, which Home Depot says, this is a case management tool. You can't, in an MDL, apply to individual cases rulings that you make. But if you bring them together, if you do a consolidated complaint, if you do a CMO, if you issue orders for everybody, you can bring in these legal claims, and you can decide them once for all cases, which is exactly what the
But
plaintiff
again,
asked
that's
for.
different because in Home Depot, the court recognized that in MDLs, cases retain their separate identities because they're filed separately, not the ones where there are a bunch of joint plaintiffs, unless they choose to proceed on a consolidated master complaint. So it differentiated what I'll call here Wave 3 from Wave 4.
That's correct, Your Honor, but if you go back a few pages before that, the Home Depot court also says, and CMOs are another mechanism by which the judge in an MDL court could bring people together.
No doubt, but it doesn't say that a CMO, and we're not bound by this, but it doesn't say that a CMO, as a matter of law, always is consent.
Right. No
So-
question about that. No question
So
about
argue
that.
it in terms, how is it that you see the Group 4 plaintiffs as having had a fair opportunity to litigate the duty to warn claim? I know you don't go back to the CMO. I just don't
Well-
see how they had an opportunity.
But Your Honor, to say that when they agree to be bound by representative decisions, that's what they did when they asked for the CMO. They came to the court and they said, enter the CMO so you can decide things once. And Wave 4 did that.
So you view it as like
That's exactly what Taylor says.
some kind of agreement to
Absolutely.
claim preclusion going forward?
It's
Or issue preclusion?
It's what they asked for. They asked the judge to issue a CMO so that they could have threshold legal issues decided once.
But I think you're
That's
reading
Wave
it
4.
How is
so
this a-
broadly.
How is this a threshold legal issue when it's the application of law to the facts?
Well,
It's a summary judgment. If you said, okay, they were bound by an agreement that here's what the standard for negligence is for this claim in Wisconsin, that would be compelling. You decide that once. But a summary judgment, you're applying the facts and the law and making an individual determination. How on earth could that language have been in agreement to be bound by that?
Well, and as they said in the motion to sever, now this is a different group of plaintiffs, but still on the plaintiff side, failure to warn is particularly conducive to a.
But the court
a
denied the
threshold.
motion to sever, so that
Well,
doesn't help you.
But the court said we can address the trial's individual discovery without the disadvantages of severance, and that's what the court.
It's
tried to
almost
do.
like you're
But-
arguing that a combination of consent through the CMO and notice through the personal jurisdiction, it's the combination of those two things that you think sum to fairness vis-a-vis the Group 4 plaintiffs.
Absolutely. They asked for it, and they were on notice that it was going to apply to them. And the plaintiffs, after Cyaneman were
And
dismissed,
so if
didn't
we were to
stand.
disagree with you on either of those branches of your argument, we would have to rule the other way and say they get their day in court. If we didn't think cyanamide meant that much, or if we didn't see it as such an across-the-board agreement.
If the court looks at the entirety of the record with the CMOs, the plaintiff's request, the dismissal of Cyaneman, and Judge Edelman's interpretation of his own CMOs of how he handled this litigation, I think the conclusion is fair, that the Wave 4 plaintiffs did have an opportunity to participate and that they were engaged in the litigation. And under Taylor and Home Depot, that's sufficient to apply issue preclusion.
Okay, very well. We'll hear from your colleague.
Thank you, Your Honor.
May it please the court, Brian Schmalzbach for the appellees. I'd like to briefly address why, even if the Group 4 plaintiffs could relitigate the necessity of a warning here, summary judgment would still be required on that common question. That's that, as a matter of law, there's no need to warn of risks under Wisconsin law when there's ample reason to believe that those risks are already known. And that was the ultimate holding in Burton, and that was the point that the Wave 2 plaintiffs conceded, and they were right to do so. And the new evidence that plaintiffs purport to marshal here, evidence that they didn't bother to present in Burton, didn't bother to present in Wave 2, doesn't move the needle at all. I'll start with what the standard is and then why plaintiffs cannot meet
But
it.
why couldn't the Group 4 plaintiffs bring up that new evidence now? If we find that Taylor applies, why couldn't they go back and bring up that new evidence? I agree on Wave 2, that ship has sailed. But Wave 4, there's nothing, if it goes back, that would preclude them from raising this new, it seems almost a new theory in a way.
Right, and to be clear, I'm assuming, contrary to what Mr. DeJulius explained and what I believe is right, that they can raise this new evidence and relitigate that question now.
Okay.
That's the premise
I
of this.
misunderstood. Okay.
So,
Group
so
two?
you're talking about Group 4 or Group 2?
I'm talking about
Anybody?
anybody. Most of the discussion was about Group 4, but I'm addressing the merits, which the court doesn't need to reach, but if it wanted
Right.
to.
I don't see why. I mean, in light of the proffered evidence, it does seem that there's a distinction between knowing that little children might eat paint chips versus realizing that even though it's a pristine place and there aren't any paint chips around, there's still this dust that gets in. Though that, I mean, I don't know the answer, but it seems to me that there are views on either side of that.
And it seems like, just to pick up on that, that's not something we should be doing in the first instance on appeal.
If it were necessary to reach the merits, the court could remand. But I want to explain briefly why the Wisconsin duty to warn standard is such that it's actually a very easy question. And it's an easy question that will make sense in light of the Wave 2 concession. So the reason it's an easy question is because of that Strasser standard. This is the
So I'm sorry to interrupt, but just in order to agree with you then, we would have to agree that Group 4 is bound by the Wave 2 concession?
No, not at all, Your Honor.
All right.
This is a separate argument.
Okay, you just threw that in. So
I'm assuming-
You threw me off.
Sorry, I'm assuming hypothetically in the alternative that you're reaching the merits, which, again, we
For
don't
Group,
think you
let's
need
just
to do
say we're reaching the merits for Group 4, for
Certainly.
simplicity purposes.
for simplicity.
The merits of the duty to warn question.
That's right. Which is under Wisconsin law. That's a question of law. It's probably fair to call it a mixed question, but Strasser itself, citing the Rockwhite case, says that this is a question of law where there's no dispute about the underlying facts. And that is what I propose is the scenario that we find ourselves in. There's no dispute, even granting the plaintiffs this additional evidence that they want to marshal at this stage. We're not taking issue with that factual evidence. We're taking issue with its relevance. And it's irrelevant under the Wisconsin standard, which is a purely objective standard that looks at what manufacturers had reason to know. Under Strasser, it says that the plaintiffs must show that the manufacturer, quote, has no reason to believe that the plaintiff will realize the product's dangerous condition. So a lot of the new evidence that was propounded recently, my friend on the other side said it's affidavits from plaintiffs or their caregivers. That subjective individual evidence is irrelevant because it doesn't go to the objective standard of what manufacturers had reason to know. And so,
But how would you propose to prove that? I mean, the plaintiffs are showing that the public at large, I mean, there were no articles, there were no things warning in particular about the dust that as the paint slowly degenerates, the dust that's in the air that's inhaled.
Right, you're right.
I mean, if there had been, a Surgeon General report or if there had been some industry report, I mean, something, but they're saying The fact that none of these people knew is some evidence that a reasonable person, you know, your paradigmatic objective standard, also would not have known.
Right, Your Honor. And let me address that point directly. What manufacturers would have seen out there in the world at this time is this, that in 1992...
And this time means the 90s, roughly.
The 90s through the early 2000s.
Yeah.
So by 1992, Congress had adopted the Residential Lead-Based Paint Hazard Reduction Act, which did two things that are dispositive here. One is it made these legislative findings about the risk not only of lead paint in general, but of lead dust in particular. So lead dust is absolutely being highlighted at this point. But more importantly, what Congress did is it mandated the disclosure of that lead dust risk to buyers and renters. So if you're a manufacturer at this point, what you see is that by the mid-90s, every single buyer and renter of pre-1978 homes where there might be lead paint on the walls is to receive this mandatory pamphlet from the EPA. And you can
But
see
I
it.
understand that pamphlet only goes to new buyers and renters, so there are many people in existing stock who never see any such thing.
That's right, Your Honor. And it's also to be given to those who renew their leases. So this would be something that plaintiffs and their caregivers, people in their position, would receive even if they were already in a house.
It sounds like you're raising issues of fact on a merits issue before the Court of Appeals that haven't gone through the district court.
So this is in plaintiff's evidence, Your Honor. This is in the new evidence that they wanted the court to consider. So I'm just using what they're putting in front of you.
But we don't know what new evidence Wave 4 wants to enter, do we? I don't think summary judgment was ever filed against them. Now you're saying that the new evidence raised by Wave 2 is going to be the same as what's raised by Wave 4, and at the Court of Appeals, we should accept that when it hasn't gone through the district court.
No, Your Honor. All this evidence came in at the summary judgment stage when summary judgment was entered against all of the remaining plaintiffs. So the Wave 4
It would apply to
plaintiffs,
Wave 4 too?
Yeah, they participated in that. They had the opportunity. This was their evidence. This was their evidence that they introduced, and that proves the opposite of what they need to prove. Because what a manufacturer is going to see is that every renter or buyer is going to have access to this information. It has to be given to them. And that pamphlet that the EPA produces, which is at DSA 232, it walks through all the warnings that plaintiffs say should have been given here. It walks through the fact that lead dust may be invisible. It walks through the fact that children may inadvertently put lead dust in their mouth through normal mouthing behaviors. All of those warnings are there. They're out there in the world, and they're out there in the world in a way that Congress designed to get in front of plaintiffs, their caregivers, and people in their position.
Can you back up just 1 second? Because I want, what summary judgment proceeding did the Wave 4 Velo and Gibson plaintiffs participate in?
So that all the plaintiffs are up here now because summary judgment was granted against them. And my friend, Mr. DeJulius, explained why that was correct on issue preclusion grounds for the last group of plaintiffs. But they all had the opportunity to put this evidence, and did put this new evidence into the record.
Okay, so that all you're doing is you're kind of circling back to the points he was making about the preclusive effects.
To be clear, my argument isn't relying on preclusive effects. My argument is just saying, even if they did require the ability to relitigate these questions, the evidence that they would use to relitigate it, the evidence that they have tried to use to relitigate it, doesn't help them.
It's in the evidence that's in the appendices.
Right, that's right, Your Honor. So for these reasons, manufacturers would see out there in the world that everyone in the plaintiff's positions should have been given this warning for reasons that Congress mandated. And so it's impossible for plaintiffs to show what they must show to survive summary judgment, that there was no reason for defendants to expect awareness of these risks. So on these common questions that plaintiffs shouldn't be able to relitigate, which I reiterate is our primary position, even if they were to relitigate them, they could not prevail on those questions anyway. If the court has no further questions, we'd ask you to affirm.
Okay, Mr. Smallsback, thank you very much.
Thank you, Your Honor.
Ms. Fitzpatrick, we'll hear from you, and we'll give you the rebuttal time that you asked for.
Thank you, Your Honors. May it please the Court, Fidelma Fitzpatrick on behalf of the plaintiffs and the appellants.
I hate to throw you off, but just a quick question in light of what we just heard. Can you clarify, did the Group 4 plaintiffs participate in a summary judgment motion below? Or
The
waive
answer-
for, whatever you want to call them?
The answer is initially yes and then no, and let me explain the answer to that. And you'll see this at the appendix in 818. When the cases were remanded from Burton 2, they came in front of Judge Edelman again. The plaintiffs asked, all plaintiffs asked, including the Group 3 and Group 4 plaintiffs, asked for additional discovery because what they wanted to be able to do was to address the factual issue that the Burton 2 court had recognized. And what Judge Edelman said at Appendix 818 is he said that the remaining plaintiffs, that's Group 3 and Group 4, have not had an opportunity to conduct discovery into this issue, and I am very reluctant to deny them that opportunity. Such evidence would be essential in opposing the defendant's motions for summary judgment. He goes on and then recognizes that the question that has been remanded to this court that he's considering on summary judgment is an objective standard and presents an issue of fact, a question of fact. What happens then is the Group 3 and Group 4 plaintiffs then put in not just affidavits from their own caregivers, but affidavits from expert witnesses, included Dr. David Jacobs, who worked in the federal government, to say that the consumer expectations and the consumer was not, in the 1990s and 2000s, was not sufficient. Judge Edelman then, in granting the summary judgment, ignores all of that evidence. He never looks at it. He never considers it. He just says, I know all of that's out there, but I'm not even going to consider
He
it.
essentially says, I made a mistake because you could have explored this before, doesn't he?
He says that
That's
you
right.
could have explored this before, which would have been going back to the Wave 2 plaintiffs,
Right.
could have put this in their original summary judgment motions, which were briefed and argued pre-Burton 2. And what's significant about that, Your Honor, is post-Burton 2, when we come back with a different, or I'm going to call it a clarified legal and factual landscape, the defendants, including defendants who had not availed themselves of certain arguments of Burton 2, used those arguments before Judge Edelman to have a new, renewed summary judgment. We were responding, plaintiffs were responding to the renewed summary judgment motions that had been filed by the defendants that were based off of Burton, which is why we had asked for the opportunity to do that factual record. Judge Edelman does ultimately decide that he was mistaken, but the reality is this court sent back with a factual question. And I think that I want to focus just on my very brief time remaining on Group 3 because I think it's very important here. There is this fallacy that has been perpetuated by the defendants that Group 3 was somehow consolidated for all purposes in what we have going on. We know that is not true. First of all, Allen ECF 160, the Judge Edelman looking at the severance and looking at the misjoinder specifically says he's doing it for administrative purposes and recognizes that each individual plaintiff will have individual discovery and will have individual opportunity to brief their cases and try their cases. Secondarily, throughout the below proceedings, these defendants, and particularly Sherwin-Williams, consistently acknowledged that issue preclusion cannot and does not apply in these cases because the plaintiffs do not have sufficient identity of interest. And they do that in a number of different places. Allen ECF 362, where they say specifically, and I think that this is instructive, the court, which is the district court, has recognized that even the first 3 round of plaintiffs, the plaintiffs before you on Burton 2, did not share an identity of interest for purposes of issue preclusion. The jury had to make separate findings on questions of ARCO's liability for negligence and failure to warn for each plaintiff on 3 separate verdict forms. The jury's decision on those questions for one plaintiff did not bind any other plaintiff. And that was for the 3 plaintiffs who had their cases tried together. Sherwin-Williams admits that there's no identity of interest. They go on in ECF 447, where Judge Edelman denies the ARCO motion for issue preclusion. And what had happened there is ARCO had won at the initial trial and had filed for issue preclusion. And the judge said, no, we can't file issue preclusion for all cases going forward for all other plaintiffs because there's not sufficient identity of interest and we have a combination of complex legal issues and complex factual issues that all other plaintiffs are going to have the opportunity to come forward and present in their individual cases. And then we also have Allen ECF at 883 and Allen ECF at 1033, where again, Sherwin-Williams and Armstrong specifically argue that issue preclusion does not apply in these particular cases. It is a fallacy that Judge Edelman, or through these case management orders, was dealing with all of the 140-odd plaintiffs that were on those two complaints collectively. Each one of those case management orders and each one of the issues that was decided in one of two ways throughout the entire pendency of this litigation. Either one, a motion was filed for partial consolidation on an issue and an issue of fact, and that was something, for example, in a protective order, which is ECF 207. Or separately, there were individual cases, so there were individual plaintiffs and different motions for summary judgment and different motions were filed as to individual plaintiffs. But the reality is those wave 3 and those wave 4 places, group 3 and group 4 plaintiffs vis-a-vis wave 1 and wave 2, discovery was stayed. They had no ability to conduct discovery while wave 1 and wave 2 were going on. They had no ability to present any arguments at summary judgment. They had no ability to present any argument on appeal to this court during Burton 2, and they simply were completely denied their entire opportunity to have their own facts, their own evidence considered by either an appellate court or by the district court because of the way that Judge Edelman decided that he was going to manage this docket and how he was going to handle those group 3 plaintiffs that were on the same complaint as a trial plaintiff but had not had their cases activated. And that is the issue that is one of the key issues that we're in front of, because those plaintiffs have not had their due process opportunity. They had no notice that their cases were being heard. They had no opportunity to have them heard. And they are now stuck with litigation decisions that were made in the context of motions that were filed on behalf of very specific plaintiffs. And I know that I'm over my time. Your Honors, I appreciate the time.
Okay, thank you. Yeah, thank you very much. We really thank counsel for all parties for the time and care that's gone into the briefing and the argument. We'll take the consolidated appeals under advisement. Thank you. Okay, we'll move to our third appeal of the morning. That's in case number 23-1392, Melody Pack versus the President of the United States, Joseph Biden. Is it Ms. Sustick? Good morning.
Good morning. Good morning, Your Honors. May it please the court. My name is Veronica Sustick, and I represent the plaintiff appellants. This case is about two things. First, it's about what an agency must do before it can permanently separate U.S. families. Second, it's about whether an executive agency is permitted to have a policy of not doing what Congress has told it it must, and whether this court can use its power to serve as a check on unlawful agency action. We ask this court to reverse the district court's decision because the court dismissed this case under the doctrine of consular non-reviewability, which in general bars judicial review of consular visa decisions. Consular officers do have the authority to make decisions on individual visa applications. That's a very broad and well-settled authority, but those decisions must be based in fact, they must be rational, and they must be made pursuant to procedures laid out by the law.
So, Ms. Sustick, I mean, obviously you know you're here with an uphill battle given the scope of the consular non-reviewability doctrine. So I'm wondering, looking at section 1182A3, capital B, little 1, the Supreme Court has seemed to have said that as long as the right part of the statute is cited in the denial order, that carries with it a presumption that that in fact is what the consular officer was doing. So why was the, brief though it was, explanation here inadequate?
Your Honor, the Supreme Court has indeed in Din said that a statutory citation is sufficient for a facially legitimate and bona fide decision to be found. However, the court left open the possibility of attacking that decision where bad faith has been affirmatively alleged, and we are affirmatively alleging bad faith. So
But don't you have to back that? I mean, it can't be so easy for somebody simply to come in and utter the words bad faith. And we've recognized this before. It's going to be very hard to show that, and maybe you can just summarize what you think your best evidence of bad faith is.
Absolutely,
And if you
Your Honor.
could, in answering that question, just how that squares with Yaffe, with our opinion in Yaffe.
Understood. So in Yaffe, this court said that bad faith could mean dishonesty of belief, purpose, or motive. The court in Din did not actually explain or describe what bad faith would be, just left the door open.
So can I say, I mean, I think one of the things we've been thinking about is perhaps, you know, if there were some collateral evidence that the consular officer was taking bribes or that the consular officer was deciding on the basis of a constitutionally impermissible reason, you know, maybe some like little tiny escape hatch for these things. But I don't see that here. And can I ask you a factual question? Did any of, none of these people served under the Shah. You know, it was the Islamic Revolutionary Guard Corps, and that inevitably to me means, and looking at the dates, all after the revolution.
All of the plaintiffs served in 1979 after
Right,
the revolution.
so the revolution
or
is right
after.
around 1979, but if it was the Islamic Revolutionary Guard Corps, they were serving, even the ones who served all the way back then, not the ones who served more recently, in an organization whose overall mission was actually quite hostile to the United States.
Your Honor, that is part of the analysis that needs to be done. So for conscripts who served prior to the formal designation of the IRGC in 2019, it is a Tier 3
Right.
analysis that has to be done. So there has to be a finding that it was indeed a terrorist organization at the time of the applicant's service. So even if there is a finding that going back 45 years to, or 44 to 1979, it was a terrorist organization, that's not the end of the inquiry. There also has to be a question of what did the applicant specifically do to complete their military service? So some of our plaintiffs painted walls. It was essentially civil service, so we had an engineer who went and built hospitals and built bridges, took pregnant women to doctor's appointments. So that is another part of the question. And then there's a third piece, which there is a mental intent component. So did you voluntarily and knowingly serve on behalf of a terrorist organization? Our bad faith allegation rests in large part on those latter two pieces, because an individual's actual activities in the military are never requested in any of the visa application process. They are not routinely asked during visa interviews. And when our plaintiffs did try to offer that evidence, their efforts were rebuffed. They were just told no, or they were directed to an irrelevant agency to submit an irrelevant waiver that would
Isn't
waive
that
the grounds.
asking us, though, to get into the counselor's decision and thought process for why he made this decision, which is exactly what we're not supposed to do?
I don't think so, Your Honor.
Because wouldn't we have to evaluate why he decided what he did?
And actually, to add to what Judge St. Eve is saying, aren't you really arguing for a requirement of an explanation? You know, not just a citation of a statute, you know, but an actual opinion or something, or a memorandum explanation. Because if you had that, then you might be able to follow up on some of those other questions, but there is no such requirement to my knowledge.
That's correct. There is no requirement that visa applicants receive anything more than a citation. We're not asking for anything more than the citation that received. We're not asking for a subsection with specific allegations of whether it was material support or.
But what you are
soliciting.
saying is that in your view of the facts that attached to your client, that the decision-making was so flawed that it had to amount to bad faith. That's effectively your argument.
That's right, Your Honor. And the reason that is because there is evidence that defendants are actively refusing to take any of the evidence required to make a valid decision. So essentially, through the standard visa process, they receive a military ID card, which states a person's name, their date of birth, and the years of their service. That's all it says. That is sufficient for a Tier 1 designation. So if you have an IRGC conscript who served in 2020, so after the April 2019 designation, they give you that military ID card. It says IRGC, it says 2020. That's the end of the inquiry for a consular officer.
But doesn't that just get back circular to why the counselor made the decision that the counselor made? And we'd have to dig into that a bit, which we're not supposed to do.
I think what the court can do is look at what the statutes say, what are the actual facts, what are the elements that need to be found, and and we were dismissed at the motion to dismiss stage, so we didn't have an opportunity to prove any of our allegations. Our allegations were that they were never asked, it is not elicited through the normal visa process, and when they attempted to submit that evidence to try and get exemptions and waivers, they were turned away and the door was shut to their ability to prove their innocence, essentially.
And wouldn't that require an assessment of that evidence that you wanted to submit?
It would require an assessment by the consular officers, but they're refusing to take any evidence. That's the threshold question, is they are refusing to allow people to prove eligibility, which it is the visa applicant's burden to prove.
So can I ask this? I mean, I can't, in my own mind, figure out how your system would work without the court's access to the file that the consular officer used. And you're making an assumption that the only things in the file are the things that the applicants themselves submitted, but I'm not sure that's necessarily true.
Well, we are making two allegations, which is that there is a broader process problem, which wouldn't require necessarily looking into individual visa applications. The bad faith question, well, I don't think that would require looking into it either. What we have alleged is that they're not taking the evidence, and it's evident on the face of the standard visa application, which Your Honors could look up online. It is there for anybody to look at. Those things do not ask those questions.
I think Judge Wood's point is perhaps broader. I don't want to speak for, but the point is that your clients are they're applying for a visa, they're going to make certain representations, right? But the executive branch of the government could very well have a perspective on the organization and its kind of state as of a particular point in time. And here, that point in time is well before the 2019 designation.
Yes, Your
right?
Honor, but that's not where
and that's information that's not privy to the visa applicant.
But that's not where the inquiry ends. The applicant, the consular officer has to figure out what were the applicant's activities and what was their mental state, which requires that evidence actively be taken at the...
But after taking account of the executive branch perspective, here you have the consular officers that invoke the, 1183A3B provision expressly, right? And you're asking us effectively to somehow conduct judicial review of that that decision is so flawed from the applicant's perspective that it has to amount to bad faith, and that's going to pry open some form of judicial review.
The courts, the Supreme
and
Court...
I see a separation of powers problem on that. What review would we conduct and under what standard? And the executive branch could I think, take the position, we are not willing to expose our intelligence about XYZ organization as of X date. We're not willing to do that.
In our view, it doesn't require revealing any national security secrets, and respectfully, these statutes that lay out the Tier 3 designation That was already written by Congress with national security in mind, and it told consular officers the specific elements they have to find in order to make these
But it was also written
decisions.
by Congress against the backdrop of the consular non-reviewability doctrine. The reason I started out with the statutory citation is, I think in this case, although correct me if I'm wrong, that there was just a generic citation to 1182A3B, and the officer didn't dig into subpart Roman numeral 1 or subpart Roman numeral 2. And so I wondered if you were at all making the argument that even the statutory citation wasn't complete enough to understand exactly why the visa was being denied.
We are not making that argument. Of course, it would be lovely if we could get more detail, but that's not the argument that we're making. We are simply saying that the statutory citation, where you're looking at Tier 3, the statutory citation is sufficient.
Okay.
Where you're looking
All
at
right.
Tier 3 applicants, the process is not sufficient to get the information that Congress has required the agency to take.
Now, before you, you are out of time.
And I am
Can
out of time,
Can I
yes.
ask
Sure,
one? I
sure.
have one other question, because I think a predicate problem that you have is locating some kind of judicially enforceable right to enter the United States in the first instance, because your clients are all non-U.S. citizens. You need to go through this complex determination about whether the rights of a U.S. citizen, actually one of them is a lawful permanent resident, I think, but let's stick with citizens, are those rights being implicated when the family isn't permitted to reunite? And so I just put that out there as another complication for you.
Sure, and the court in Din left that question open.
Right,
They
it's
assumed
been
that
open
decide,
ever
yes,
since,
and this
yeah.
court has decided not to decide that up to this point. And so our argument is just that the U.S. citizen plaintiffs have an interest in the visa applications, the petitions that have been filed on behalf of their family members, and that there is a right in the United States, an important and longstanding right to family unity, not necessarily a right to entry of the visa applicants, but a right to family unity that can only be deprived after due process has been given, and they have not been given that.
Okay, great. We'll hear from your colleague.
The colleague.
Oh, yeah, you're reserved, you got rebuttal, right? Okay. Okay, so we'll hear from the government. Yep.
Good morning, Your Honors. May it please the Court, Victoria Tercios on behalf of the government. The Court should affirm the District Court's dismissal of this case based on the doctrine of consular non-reviewability and the APA's general preclusion against judicial review of consular officers' decisions.
So answer for me the question that I alluded to earlier. Suppose a particular consular officer, regrettably, is for sale, and that person, charges $10,000 to make a favorable visa determination, and if people who don't pay the money don't get the visa determination. You're saying that there's no way that could be reviewed in a U.S. court?
No, Your Honor. The general presumption is that the decisions of consular officers are not reviewable by the courts. However, two exceptions to that general rule do exist. First, the Mandela exception for U.S. citizens, and second, a bad faith exception. But the plaintiff still needs to make an affirmative showing of bad faith before the court can review a facially legitimate and bona fide decision of a consular officer. In this court's precedential decisions in dicta, we've understood that an affirmative showing of bad faith might look like a consular officer refusing to consider certain evidence or evidence of some religious discrimination.
So let's stop on the first for a minute. Suppose it becomes clear, maybe there's somebody who works in one of the embassies and is willing to talk to interested people, that there's a particular consular officer who just throws in the wastebasket all things proffered by the applicant, and just, in the afternoons issues yeses and in the mornings issues nos. Is that something that a person could attack in court?
That sounds like bad faith to me, Your Honor, but that's not what has been shown in this case.
Well, but what I'm getting to, though, is you're beginning to reach a point where refusal to consider the information in the file, is that bad faith?
Well,
Or refusal to put information in a file?
the plaintiffs have alleged that consular officers have refused documents in their case, but that is
So they refuse to
inaccurate.
add to the file things that are pertinent to the Tier 3 determination.
Yes, but that's inaccurate. The consular officers had already issued final refusals in every case before the plaintiffs, through counsel or the visa applicants themselves, reached out to the consulates with additional documents. So every visa applicant had already been refused a visa before.
So are you saying there's no obligation to consider these additional documents at the time to do it would have been before the visa
That's
application
correct,
was?
Your Honor. The regulations say that if a consular officer has receives documentary evidence, they're required to consider it, but the plaintiffs have not pointed to any regulation or statute which would require the consular officers to reopen a visa application after they had already been
So you're
refused
saying
a
after
visa.
these refusal worksheets have been, there's already been the finding made? That's
Yes, Your
when
Honor.
the evidentiary proffer or the factual proffer came forward?
Yes, Your Honor.
Okay.
And as to, if I can move to the second exception, to the Mandel exception, the Supreme Court said that a U.S. citizen may bring a challenge to a visa refusal where their constitutional rights have been burdened, but that courts should not disturb the facially legitimate and bona fide decisions of consular officers. And as Judge Wood noted earlier, a facially legitimate and bona fide decision is evidenced by a statutory citation to the basis of refusal. In this case, the 1182A3B, the general terrorism-related inadmissibility grounds.
But
And-
looking at A3B,
Yes, Your Honor.
4, there are differing things that are identified here, and I guess you have to assume that the person did the least important of these things. Like subpart 6, to commit an act that the actor knows or reasonably should know affords material support. Now, we've coped with this material support language in other contexts. You know, is material support taking people to a hospital? What is material support?
That is a factual inquiry that would be determined by the consular officer at their discretion. And this court has considered whether inconsequential conduct by a visa applicant is validly considered to be found to be terrorist conduct. This court considered that in Hazama, where the plaintiff admitted, or the visa applicant admitted to having thrown rocks at soldiers, and this court said that any recharacterization or reinterpretation of conduct that the consular officer reviews in making inadmissibility determinations would turn consular non-reviewability on its head. So,
But we did say that throwing rocks, you know, that you wouldn't have to take leave of your senses to think that throwing rocks was a hostile act, could actually kill somebody if you hit the person in the right place, and so forth. But we've had other cases in a somewhat different area where the idea of material support has come up. So, for example, what if an organization runs daycare centers? They call it Hamas, and they run daycare centers, and that really isn't something that's hurting anybody. It's taking care of little children, and yet supporting the daycare centers has been held by us and others to be, sort of on a dollar's a dollar idea that this is one thing that Hamas is doing that furthers its overall mission. So I want to know, because if it gets that broad, then it actually means breathing. It means doing anything is material support if you happen to be a member of the organization. I want to know if that's the government's position.
yes, Your Honor, that there shouldn't be any inquiry into the exemption eligibility determinations or the inadmissibility determinations. And actually, a question of whether or not the conduct made you inadmissible is a direct attack on the inadmissibility determination, which is the government's core argument in this case, that this is an indirect attack on the consular officer's decision itself. In Matushkina v. Nielsen, a plaintiff challenged an inadmissibility determination that had been made several years before a consular officer actually refused a visa to the applicant. And this court said that because that inadmissibility determination formed the basis of the consular officer's decision to refuse the visa, that the court would not review it, that it was an indirect attack. and was not permissible.
Do you think there's a way a way to plead a claim outside of an indirect challenge if you're more kind of programmatically challenging consular determinations on the basis of, say, for example, corruption? Say a former consular officer came forward and said, I need to blow the whistle on this. These are all very procedurally deficient. There's really no review going on, et cetera, et cetera. Is there a way to lodge that kind of claim?
I think
Or would the
under this
government take the position, no matter how it's styled, it's an indirect challenge because that the only plaintiff that's going to have standing is somebody that was denied a visa?
that the only a visa applicant could.
Yeah. In other words, is there a way to bring a programmatic challenge to these things?
I don't believe under this court's precedent in Matushkina that there is, Your Honor.
Because everything's indirect.
Because the inadmissibility determination and the exemption eligibility determination are predicate decisions or determinations that a consular officer makes in deciding whether someone is or is not eligible for the visa that they're seeking. So, at least at the way that this case has been pled, there can be no reading of it that it's a programmatic challenge.
So there's no conduct, however trivial, that these people could have engaged in once they were. So what's the difference between Tier 1 and Tier 3 at that point? Hasn't the government just erased it?
Well, a Tier 1 foreign terrorist organization is designated by the Secretary of.
Yeah, but substantively, I mean, because you could be Tier 3, and all the officer has to say is, "Oh, I think you're a Tier 3." I mean, because you bought a box of Kleenexes for somebody, you know, is that it?
Well, the statutes themselves provide consular officers with that discretion, Your Honor, in making those determinations. And I would cite again to the decision in Hazama that we're recharacterizing the conduct or reinterpreting conduct that the consular officers.
And I'm just saying, Hazama at least was violent conduct. I mean, there's something. It was stated in the materials. It was accessible. You could make a decision about that. I'm well familiar with Hazama, but I just don't think it's the same as what some of these plaintiffs are asserting, which is that they were engaged in the most menial, you know, non-military type tasks imaginable. They weren't throwing rocks at people.
Yes, I would say two things. First, I believe it was you, Your Honor, mentioned earlier that we don't have all the facts that the consular officers had before them in the record. It is in the record that the consular officers interviewed these visa applicants and that some of the visa applicants underwent what is referred to as extreme vetting. So we don't have all of the conduct before us. And second, as I believe the panel mentioned earlier, we don't have the specific statutory ground for inadmissibility before us either. So we don't know if it was material support that these visa applicants were found to be inadmissible under. It could have been.
But the latter is a problem, isn't it, under the Supreme Court's Din decision, if we don't have a full citation?
Well, we have the general citation to the terrorism-related inadmissibility grounds, and that was the same citation in Din.
What if they just cited, you know, to Title 8?
Well, so generally, 1182b1 requires a consular officer to provide a more specific ground of inadmissibility when a consular officer refuses a visa. However, 1182b1 does not apply when a consular officer refuses the visa under the criminal inadmissibility grounds or the terrorism inadmissibility grounds. Here, because the terrorism inadmissibility grounds were cited, no more specific ground is necessary.
Is it the government's view that Justice Kennedy's concurring opinions controlling in Din?
Yes, Your Honor. And I believe other circuits have taken that same position as well. There are no further questions, and I can sum up.
Okay, very well.
Thank you, Your Honors. Sorry.
No, go ahead.
Because this court has held that indirect attacks on a consular officer's decision will implicate consular non-reviewability, the district court did not err in determining that plaintiff's claims were non-justiciable. For that reason, we ask that the court affirm the dismissal and the government rests on its briefs. Thank you.
Okay, very well. Okay, now we'll go to rebuttal.
Good morning, Your Honors. May it please the court. My name is Shabnam Lutfi for the plaintiff appellants. Well, where to start?
Ms. Lutfi, let me ask you a question to start, please. How do you respond to the argument that in order to find for your client that the council would have to reopen the visa application, that the counselor denied the visa application? Your claim is they ignored this additional evidence that was presented for an exemption after the denial, and there's nothing that requires the counselor to consider additional evidence after the counselor's already denied it.
The counselor officer absolutely should reopen the applications because those decisions were unlawful. To make a Tier 3 determination, as Judge Wood pointed out, under 8 U.S.C. 1182 A3B46 CC and 5 CC, 6 DD, and 4 CC, every place in the law where it discusses a Tier 3 terrorist organization, there is additional fact-finding that must take place. Under where it says the material support, if the applicant committed material, or the actor knows or reasonably knows, affords material support, then to a Tier 3 terrorist organization, unless the actor can demonstrate by clear and convincing evidence that the actor did not know, should not have reasonably known that the organization was a terrorist organization. The problem we have here is that the designation took effect April 2019, and at least 2 of these interviews occurred before the designation.
What's the source of the legal obligation to be more specific in the citation on the worksheet?
We're not asking for a sub-citation. We're not asking for that at all. What we're asking for is for the applicant to be allowed to submit evidence and meet their statutory obligation.
But after the fact, after they've already, the visa application was denied, and then each of the applicants here came back trying to submit additional evidence.
The visa application should not be denied if the application was not legally analyzed, and it can't be
But
legally
how do we know
analyzed.
that? There was an interview. We don't know what the counselors knew. To accept your argument, we would have to assume that the counselor didn't consider any of these factors in the first instance.
The factor to be considered is the applicant's intent, their mental state at the time of service, and nowhere in any form is the mental state of the applicant.
But why does it have to be in a form? There was an interview. We don't know what else the counselor looked at. That would, again, just be asking us to go and look at the counselor's decision at the time of denial.
We're actually not asking the court to look at the counselor's decision. We're asking the court to require defendants to meet their statutory obligation. Congress required that the counselor officer know the mental state at the time of their service.
Why wouldn't the interview satisfy that?
Well, the interview happened after the designation.
So can I
Or
maybe,
the interview happened before the designation.
can I offer maybe an analogy to the argument that I think you're making, and you can tell me if that's not right. There are times, let's say when we are hearing appeals from a criminal sentence that somebody has, that a district judge will impose a certain sentence, and the judge will say something that makes you realize the judge does not realize that he or she has discretion over a particular factor. And that's grounds for remand for a new sentence, not because the judge has to exercise his or her discretion in any particular way, but the process requires the judge's awareness that this realm of discretion exists. And I think what you're arguing is that maybe the visa application will be granted, maybe it'll be denied, but if the process by which it's approached is wrong, then you already have a problem, because at least you've been deprived at least of the possibility of a more favorable result.
Correct.
That's your argument.
Yes, and there is a Second Circuit case that is worth pointing to, where the Second Circuit found that the word "unless" in the statute triggers an affirmative obligation on the government to provide a meaningful opportunity for the visa applicant to sustain their burden.
How do you know the finding that you want much more express? How do you know it's not being made?
The visa applicant has never been given the chance to prove their intent. which is required for a Tier 3 determination.
And the statute says the actor, not the government.
Correct. The actor, the applicant, is required to prove their mental state at the time of their civilian duties, their military service, and they've been deprived of that. That's all we're asking for. The chance to meet their statutory burden, and for the defendants to be required to fill out Congress's statutes as written. That's all we're asking for. These decisions, and if I, well, I'll
No,
wait.
go ahead. Go ahead. You can finish your
So
thought.
I'll just finish. Defendant appellees ask this court for a blank check to deny anyone for any reason, with or without evidence, under the Trigg grounds, and for this court to look the other way. Defendants fail to abide by the binding statutes to solicit the information needed to make these determinations, and if this doesn't meet the definition of a visa decision that is not facially legitimate and bona fide, I don't know what could, because there's no evidence. At least in Yafai, there was some credibility issues or questionable stuff. Here we have no evidence at all. The statute requires fact-finding. Mr. Puck, Mr. Faturi, they served in the 1980s. The consequences of defendant's conduct is similar to the severity in a criminal matter, except the applicant here has been deprived the opportunity to prove their innocence. The crime committed for Mr. John Doe 2 is calligraphy, not serving in a war zone, but calligraphy on a wall. All plaintiffs completed civilian duties, and we ask for the opportunity for this case to be heard on the merits.
Okay, very well. Thanks to both counsel. Appreciate your advocacy. We'll take the appeal under advisement. Okay, our fourth case of the day is in appeal number 23-1534, Parents Protecting Our Children versus the Eau Claire Area School District. Mr. Berg, good morning.
Good morning, and may it please the court. When a child expresses a desire to socially transition to a different gender identity, there is a significant decision to be made by some adult about whether that's in the child's best interests. That decision has long-term implications. Many mental health professionals believe that transitioning too early can do significant harm to a child, and that the first step before making any changes is a careful professional evaluation.
So, Mr. Berg, maybe rather than discussing the merits, it would be helpful, given time constraints, for us to address whether the district court correctly ruled that that your client, that the concerns of the members of your organization are not sufficiently ripe yet, but focused yet, and such that you can't show standing. Everything is quite speculative.
Yes, Your Honor. The district's policy transfers decision-making authority over the decision about
Well,
whether...
but does it? I mean, there are all sorts of merit things about that. You're afraid that it's doing that. But the district's policy, for example, says that parents always have the right to get the school records of their child, and if there is some gender plan, parents have the right to get that. The school also recognizes that names can't be permanently changed on the records until the parents have given their... There are all kinds of things that the parents do, and this is not the only area where parents are not in the direct line. Issues of child abuse, for example, go straight to the state, not to the parents. So it's not unheard of. But I think the district court was concerned that the negative things that your clients are concerned about, which may be very important negative things, are simply a matter of imagination right now. Not that the record doesn't show that anything has happened, and that the chain of maybe this, maybe that, maybe the other thing is just too long.
There are three present harms for purposes of standing in this case that we've alleged. The first is the loss of control over this decision. So part of parents' job sometimes is to protect children from themselves.
What decision? I mean, what evidence is there that any child in the district, but any child of any of your clients' members, has been brought within the scope of this policy? For all we know, they're all children who are comfortable with a conventional heterosexual body and gender identity and everything else.
The harm is the loss of control. It's the inability to prevent the child from transitioning in school.
But what if,
Parents can no longer say no because the school will always say yes.
But what if so even though nobody has had a problem, no child has been in any way brought within the scope of this policy.
Well,
Mere possibility, isn't that kind of like Lyons? It's like, I mean, I see, or the Clapper case in particular, strikes me as a similar sort of thing where the organization was worried that the government might do something, and if it did something, it would interfere with attorney-client relationships and other important interests. But the government hadn't necessarily done anything yet, and the Supreme Court said no standing.
Well, we don't know that yet. That's one of the allegations in the
That
complaint.
was the allegation in Clapper as well.
Well, one
No
of the
one knew.
allegations in the complaint is that the policy prevents parents from knowing whether the policy has been applied to their child.
And why is that different from Clapper?
Because this is a loss of decision-making authority. There was no claim like that in Clapper. There was a claim like that in Arizona.
But there was a claim of a loss of a very important interest in Clapper.
But not this type of claim, not the
well,
loss of an
wasn't-
exclusive authority, which is the claim of the parents, and that is a similar claim that was made in Arizona State Legislature. Where
Well,
the
the
court,
Arizona State Legislature had a very clear situation where it was either going to be the responsibility of the legislature to redistrict, or it was going to be okay for this commission to do the redistricting. And so that was a very concrete question. Have you been deprived of your authority to do this thing which the law required to be done? So I think that's way more specific than what you have.
let me put it this way. So if prior consent from a parent is a prerequisite, then parents can prevent the thing from happening simply by doing nothing.
But you have
If
no
prior
evidence that
consent has
any of
been
your
eliminated,
parents have been involved in
They
this.
don't know precisely because the policy doesn't give them notice or
Didn't the
consent.
Fourth
It
Circuit
allows
say, why don't you just elect a different school board? You know, I don't understand why this turns into a speculative federal case.
Our claim is that parents have a right to prior notice and consent before adults at school treat their child as if they're the opposite sex.
Mr.
The
Berg,
policy-
one of the things that stands out in your complaint is something that's missing. And that is, have you ever given your counsel on the other side, or given the school district a call and said, we have some concerns about the policy, the guidance. We'd like to sit down and talk to you about those concerns because we worry about how this guidance might be applied because it really doesn't speak in the full depth that we would prefer as parents in the event that one of our kids, were to encounter one of the issues that would trigger the guidance. You ever sat down with them and talked to them or asked to do that?
There was a lot that happened that isn't in the complaint before the complaint was
I'm asking you
filed.
right now.
Yes.
Have you ever
parents-
written them a letter?
Parents raised this issue. It was in the media.
Why isn't that in the complaint?
Because it's not relevant to standing. What's
It
relevant
absolutely is relevant. It's absolutely relevant on the imminent or actual injury prong of it. Because if not, I don't see how in the world this is any different than Lyons.
The present injury is the lack of prior notice. That prevents parents from knowing presently whether
So
the
you're
policy...
okay. So what you're saying then is because the policy by its terms prevents this information, that it's facially invalid as a matter of substantive due process.
Yes. It is facially invalid because it does not give
It's the
parents
most
prior notice and
disfavored
consent.
challenge in law. That's what the U.S. Supreme Court said in Salerno. You cannot identify a more disfavored lawsuit.
Well,
And
there's a
can I
long line of
add
cases that
given your
recognizes-
theory, I'm just going to throw in to complicate life further, that the fundamental source of the substantive due process right on which you're relying is Pierce against Society of Sisters and Myers against Nebraska and that line of cases, a line of cases that was expressly repudiated by the Supreme Court in the Dobbs decision as simply being outside the scope of what the federal Constitution was designed to address.
Your Honor, Dobbs did not eliminate that whole line of cases. It didn't
it
overrule
casts some
Troxel.
real shadows on the federal constitutional basis for these family rights, individual autonomy kinds of things.
That line of cases has not been overruled by the Supreme Court. It didn't overrule Troxel. It didn't overrule Parham. And those cases make very clear that parents have a right to make decisions on behalf of their children.
Why don't
But-
you just
but
wait until something happens?
They can't wait until something happens because they don't receive notice, so they don't actually know whether something is
They
happening. That's
receive
one of the
notice about
allegations.
a lot of things, and I mean, let me ask you this question. Does the Eau Claire Area School District, as many do, have a policy that allows parents to come visit when they wish to?
I am not sure.
I mean, in the wake of a lot of things, most school districts have an open classroom policy. The parent will check in, obviously for security reasons, and can quietly sit in the back of a classroom, observe their child. There are parent-teacher meetings. You're assuming a real lack of interaction between the school district and the parents that I'm not sure, in many instances, if it's not in the record, I suppose it's not in the record, but I'd be very surprised if the Eau Claire Area School District did not have provisions that allowed parental visits.
Let me make a simple comparison that I think might help. So every school district that I'm aware of requires parental consent to give medication at school. So let's say a school district instead said, we're going to make a cabinet available of all over-the-counter medications to students, and we'll let them take whatever they want during the school day. And it doesn't require parental notice, it doesn't require parental consent. Would a parent have to wait to sue until their child OD'd on Excedrin? Of course not, because parents have a right to make the decision about what medication their child
so
takes.
If you take that example and you translate it legally, which we have to do, okay, we have to conclude that there is no set of circumstances where this guidance could be applied constitutionally. It doesn't exist. We cannot sit here in the courtroom and hypothesize a circumstance where substantive due process rights are respected. That's Salerno. Like it,
Right.
like
yes.
it or dislike
Our
it.
position is that there is no set of circumstances where a school district can secretly begin transitioning a child at school without parental
Yeah,
notice.
see,
Where
the
does it
adverbs
say?
are the problem. The policy does not have the adverb in it.
Yeah,
I'm
nowhere
sorry, I
in the
don't understand.
policy does it
Where's-
does
where-
it forbid
point-
the parents
where-
from being told.
Where's the word secret in the guidance?
There is
What
no,
paragraph?
there is
Or
no
even where
dispute.
does it say that they won't call up the parents? It says you should first discuss it. Schools personnel should speak with the student first before discussing with the parent. It doesn't say you can't discuss it with the parent.
Well,
It
let me-
doesn't say don't discuss it with the parent.
I will get to the provisions in the policy, but I first want to say there's no dispute in this case yet about this. The district hasn't disagreed with our characterization of the policy that it lacks parental notice and consent. The district court didn't agree with that characterization. And even if there is a dispute, this is on a motion to dismiss stage. We haven't even gotten past the
What do
motion
you mean
to
there's no
dismiss yet.
dispute? They have a sentence in their red brief that says, nor has the district intentionally hid information from plaintiffs' members. That's important. The guidance does not direct secrecy. Page 25.
The guidance does lack parental notice and
What do
consent.
you mean when you say there's no contest?
And you
Both
even-
parties agree. I just read you a sentence where I think he's going to stand up and say, I disagree.
What he's saying in
He's
that
nodding his head,
situation
yes.
is it doesn't mandate secrecy in the sense that it doesn't force
What do the parties
secrecy.
agree upon? Go back 30 seconds.
The parties agree that there is a lack of notice, prior notice and consent under the policy before staff may begin treating children as the opposite sex.
But they
There's no
don't
dispute
agree
about
on
that.
that.
I'm not sure.
They
We'll
don't
see.
agree on that,
We'll
but
see in a minute.
So
Yeah.
pointing to the provision of the policy, the form, the gender support plan form, at the very top of it says, if parents are not involved in filling out this form, here's what you do.
Well,
in the
and
middle
if
of
that
the form,
form
there's
is done, the parent has a right to it under the policy as one of the student's school records.
that is true, but the form is not a prerequisite before staff may begin treating
What
the
do you do
child as
about the if
opposite.
clause under Salerno?
I'm not sure I understand the question, Your
If
Honor.
parents are not involved. Well, let me give you a hypothetical. They are involved.
The point is the policy itself on its face is facially unconstitutional because it does not give parents prior notice, prior consent before staff will begin treating their child as the opposite sex.
What if the student is 18 or over?
That's a different circumstance that's not at issue here. Again, we haven't gotten to that point of the case. This is just a motion to dismiss.
But wouldn't that be a different scenario?
Yes,
That
I
would be
agree that, I
constitutional?
agree that would be a different
Also
scenario.
potentially legal.
I agree that would be a different scenario, but again, we have not gotten to that point in the case.
Okay, Mr. Berg, we've asked you a lot of questions, maybe given you a hard time. But let's hear from Mr. Stadler, and then we'll give you some rebuttal time.
Thank you, Your Honor.
All right.
Good morning, may it please the court. My name is Ron Stadler, and I represent the defendants in this case. I think when we talk about this case, we have to focus on the principle of standing and not the merits of the issues. But I think that never before in the history of this country and its federal courts has standing been a more important issue. And I raise that, and this ties back to one of Judge Wood's first questions, because never before in our history have we seen the political nature of school boards. It doesn't matter if we're talking about to mask or not to mask, vaccines, gay pride, transgender issues. It doesn't matter what your school board does, because somebody's going to sue them over what they did. And for transgender students, it's a hotbed issue for liberals, it's a hotbed issue for conservatives. And regardless of what your school does on that issue, they're going to get sued.
So can I ask you, Mr. Stadler, whether there are any analogies in the law of Wisconsin to other areas where the school has at least the discretion, if it chooses to exercise it that way, to take an action vis-a-vis a student without notifying a parent?
Sure, and I think you raised the point earlier, was child abuse. I mean, they have a mandatory obligation if a child is suspected of being abused at home. We don't have to go call the parents up and say to them, hey, we have a concern about your child, you might be abusing them. We go directly to Child Protective Services and make that report. Parents don't have a right to control that. So it's not this all-encompassing
So
issue.
if this policy had been written in a slightly different way, just to say, our policy is to involve the parents whenever possible, only in an extraordinary circumstance where we thought that there was some risk of abuse or other danger to the child, would we move ahead without, I mean, in other words, I can imagine a policy like that, and I don't see anything in your policy that precludes it from operating that way, to Judge Scudder's points. But I think when these parents looked at that and saw that there are some circumstances where the child might go to the school and the school wouldn't immediately pick up the phone and call the parents, they became concerned about what was going on, as it were, behind their backs.
And I agree with that. We work with school districts on a daily basis, and I can't tell you how many transgender policies that I've developed with school boards. And I've yet to see two that look alike. I mean, everybody does a little bit differently, but one of the things they struggle with is, what do we do if parents don't want to be involved?
Right, but why? This is the problem with this litigation that is very frustrating, is to see the parties arguing past each other so much. Right?
We're not.
No,
we're
I
not-
think you are, and here's why. Okay, because in your brief, okay, I think you do a pretty good job of pushing back on the notion that we're hiding decisions and that the policy requires secrecy. But what you don't do is you don't take the step that's kind of implicit in Judge Wood's question. You don't say that we're going to make a representation right now in our briefing, okay? And our representation is we intend to include the parents whenever possible, absent some extraordinary set of circumstances, including, for example, danger to the student. You don't do that. And that's what I think in part is frustrating Mr. Berg and the client that he represents and the members of the organization. You say it doesn't require secrecy, but you don't go one step further than that.
But I don't have that, Judge, in the record to make that statement to you. So I can make all kinds of statements to you in a brief, but I got to back it up. And I don't have a policy that says that.
Is
But-
that the
No, but you
school's
can-
intent?
Yeah, you can
No,
make a representation.
absolutely not.
That's not the school's intent? To inform the parents unless there's a dangerous situation?
No, it is the.
No,
it
I
is
thought
the
there was
school's
some
intent.
language in the policy, maybe I made it up, that actually does say, the family will be involved, or the family is usually involved if possible.
It does, and you've got that sentence at the top that says if parents are not involved. Do you know why that's there? Because some parents choose not to get involved. And their kid may come into school and have a gender support plan drafted from them, and the parents know about it, and they just don't show up.
Well, I
'cause they
think the
don't care.
problem is the policy's not clear, that that only applies if the parents don't want to be involved.
But here's the bigger problem from a standing perspective and an Article 3 perspective. What Mr. Berg's clients want to do is direct the district's policy. And you hit it right on the head, Judge Scudder, or maybe it was Judge Wood. Elect a new school board. That's why there's no standing here. This is a policy decision made by a school board. Not a single one of plaintiff's members can come forward and say, hey, I have a child who has expressed concerns about their gender.
Or says, I have a child that I'm worried about. I mean, just I'm seeing signs that are concerning to me. I think that's what this is.
It's devoid of anything to indicate that they have a dog in the fight.
It's Clapper and Lyons. I mean, to get to we're supposed to apply the law. And standing is a big deal. Standing has separation of powers, concerns that lie behind the doctrine, when should courts decide essentially hypothetical or cases that are just too far down the road, you just don't have any of the pieces in place yet. And that's what I think the biggest issue is here. I do think there is also a facial challenge kind of problem, since we have been suggesting ways in which even this policy, which might be not artfully drafted, but even this policy could legitimately be applied. And if there are some such situations, then a facial challenge. But that's a merits issue. The question is, do we have the case joined? And what your opponents are saying is, it is a current problem because there is at least a potential for a parent in their organization to have their decision-making authority over their child taken away from them. And I guess your response is, but who knows, this hasn't happened. And that's why I was asking about the possibility of parents to visit the school, or parents to take steps to make sure that they remain informed about what their child is doing.
And if you boil down their argument, it becomes this circular thing where they say, we don't know if we've been injured, and therefore we've been injured.
How should it impact our analysis that they've alleged more than just that they have a constitutional right to make decisions regarding their children and they want to exercise that? They've cited studies in their complaint that show that it's very important from the medical professional side to address these issues with the child before certain steps are taken. That if you wait until certain steps are taken, there might be long-term psychological issues or other issues. Why isn't that sufficient to get to imminence?
Because I will tell you, it would be imminent if they could come forward and they said, I have a child who even if they said, I suspect I have a child who is going through some gender issues and is going to be subject to this, and I want to address the merits of it, and I've got these studies and I've got all this, but they don't. They just say, I'm a member of the school district. I don't like that you've got this policy. It doesn't apply to a single one of them, and it's not going to apply to them. They could have come in and they could have provided affidavits. They could have provided something to say, we've got this suspicion about having a child who is transgender, and therefore we are going to be affected by this.
Don't you think your client could help itself by putting on its website this afternoon a statement that said, we plan to implement this policy in a way that is inclusive of parents absent extraordinary circumstances?
There is a lot of action that is taking place in Eau Claire in regard to transgender issues, this gender support plan. The court's kind of presented.
The problem
with
is that
in a
it seems
vacuum.
like both of you have come into the court and you're asking us to resolve it. Not you. I mean, you're the defendant.
I'm drug along.
You're the defendant.
Right.
I hear you, but it just seems like there is room for both sides to come together on some of this, and it's just not at all clear from the plaintiff's complaint that there's been any effort to communicate with the district.
I don't disagree with that, Judge.
There's nothing in there about it.
Or to assure parents that you are going to notify them or have them part of the process unless there's a very good reason not to.
But I think those provisions in the policy, though, that you can see where it says, if a child tells you they don't want their parents to know this, remind them this is not a privileged document. It will not be
But
held.
that's only if that particular document is completed.
Right, but that's what their complaint is. This is over this gender support plan.
It's not as declarative as we're talking about.
I understand, and if we
you're
sent
capable-
lawyers to redraft this policy, it would probably read different. But it's drafted by educators.
Okay, we got your position. Mr. Berg, I think you asked for a couple minutes. You're entitled to that, so let's hear what you have to say. You're welcome.
Two main points I want to make, Your Honors. So first, the procedural posture of this case. This was dismissed on a motion to dismiss solely 12b1, solely standing. That's important for two reasons. First, to the extent there are any disputes about the scope of the policy, what it means, what it says, that can't be resolved against us at the motion to dismiss stage.
No, its absence, though, is relevant to the imminence point. And here's what I mean. If my view of this might be totally different if you had included a paragraph that said, we reached out to the school district and we wanted a meeting on how the policy was going to be implemented because of these reasons. They declined the meeting. Or they took the meeting, but then told us they have no interest in keeping parents informed of how okay, if you had a paragraph in there, don't you see how that would help your imminence argument?
I think it's clear enough from the face of the policy. The policy says students have a right to do this without parental involvement.
But the policy also does talk, if I was just looking at it, talks a fair amount about parental involvement and puts in context, that the parents aren't going to be involved. I just underlined it. Students may have these concerns that may include safety concerns, or lack of acceptance. And so school personnel should speak with the student first before discussing a student's gender nonconformity or status with the parent or guardian. But that obviously at least once each year or more often as reasonably requested by the student or their parents' guardians. I mean, the parents are in there, maybe not as clearly as they could or should be, but I think to say that this is a black and white situation is overstating it.
The policy is if a student does not want the parents to know, the school will oblige that. They've trained all of their staff
Unless
that
the
parents are
student
not
needs a
entitled
gender
to know.
conformity, a gender plan. And then the parents have an absolute right under state law to see that plan.
That
The
is
gender
not
support
that is not a
plan.
prerequisite to transitioning a child at school. But let me
To
make the
some
last point that I
forms
would
of
like to make, if I may.
Go ahead.
Even if you don't accept our argument that there are present injuries, we have separately alleged a substantial risk of injury, and that is a recognized basis for standing under Clapper. We've alleged in our complaint that this can do long-term damage to children. We've alleged in our complaint that parents have no way to know in advance when or if their children will deal with this. We've alleged in our complaint that our plaintiffs don't have any way to know if the policy has been applied to their child, precisely because of the lack of notice. Those allegations have to be sufficient, at least to make it past a motion to dismiss on a substantial risk theory, which we have brought, and we haven't had a chance to put any evidence in the record to support that. So we should at least have a chance to do that before we lose on standing. We haven't had an opportunity to do that, and so you should reverse for that ground at the very least, even if you don't accept our argument that this presently injures parents. Thank you.
Okay, Mr. Berg, thanks to you. Mr. Stadler, thanks to you. We'll take the appeal under advisement. Okay, our fifth case of the day is in appeal number 223308, Chadwick Fulks versus the warden T.J. Watson. Mr. Cranley, good morning. Good afternoon. Whenever you're ready. No, take your time.
Good morning, or good afternoon, I believe, at this point. Your Honors, we're here today in the Fulks matter. I represent Chadwick Fulks. I'm Mark Cranley. We're here after a dismissal of my client's complaint after a finding that he forged a document and gave false testimony about that document.
And Mr. Cranley, you're not, as I understand it, contesting that your client did submit a fabricated document.
We're not appealing
and your
that
client testified falsely about it.
We're not appealing that.
And you're also not appealing the dismissal of the non-exhausted claims.
That's correct.
Okay.
What we are appealing is the remedy chosen in light of at least 4 specific aspects of this case that make it different than other cases the court's handed down that have affirmed dismissal as a sanction for this type of misconduct. We recognize that the need for truthfulness of people testifying before the court is paramount. We're certainly not trying to diminish that value, that important public interest, but we think there are 4 things that make this the unusual case where a dismissal is not an appropriate remedy in this type of situation dealing with a prisoner claim. The first one of those is the nature of the allegations that were dismissed. The claim we're really asking the court to revive is the claim that Mr. Folks was sexually assaulted by a prison doctor.
So, Mr. Cranley, that claim was it not, looked at to a certain degree within the prison system, within BOP? I thought Mr. Folks ultimately called the sexual assault hotline, that he wrote to the U.S. Attorney's Office. Eventually, there's at least an administrative level finding that it was not substantiated.
Oh, that's correct. And in fact, this was one claim that was, in the earlier phases of the case, was found to be fully exhausted because Mr. Folks took those steps. And in fact, was not at issue in the Pavey hearing on whether he had exhausted.
Right. No, he definitely had exhausted, but I'm also saying he exhausted, as it were, unsuccessfully. You know, people, for whatever reason, you know, I don't know why, but found that these allegations were not well-founded.
That is a correct statement of the record, but I think for our purposes, we're here on a claim that we have not taken all the way to trial. We've not had the opportunity to complete discovery on it. We've not presented it. It's really a tantamount to a dismissal on the face of the complaint.
So the point that Judge Hanlon raised, he was the district judge, right?
Mm-hmm.
Here, that if it's fair to construe that claim, the sexual assault claim against Dr. is it Wilson?
Dr. Wilson.
Wilson as headed to trial. It didn't look like it was going to be tested at summary judgment. Looked like it was going to head to trial that way. Your client put that at risk by engaging in the misconduct on the court. Why is that not, a finding that we should respect?
Now, I think that that way of looking at it is correct in most cases. That you've put your chips on the table and you took your risk. I think it's different though when we're talking about the sexual assault claim, and that's because it's not just about Mr. Folks. Of course, it is about him and the fact that he's claiming to be a sexual assault victim, but we have concerns about are other prisoners being treated this way. The Board of Prisons has an interest in making sure its employees don't engage in this kind of awful conduct, as do other prison employees. So I think the idea that it's just Mr. Folks' chip to put on the table and take a risk is not correct. I think in a lot of other cases...
Does anything support that? Is there any case law that supports your argument?
Not on this notion of... I don't think any cases really use Judge Hanlon's analogy, but I don't disagree with the logic of this analogy. I just think in this type of heightened situation, whether it's a sexual assault allegation, it's just not appropriate.
Isn't that contrary to the court's deterrence arguments? And one of the things, you've got somebody committing fraud on the court here. Mm-hmm. And there are consequences of committing fraud on the court. The court carefully went through lesser sanctions, but concluded they were not sufficient for this fraud on the court that, quite frankly, Mr. Folks had the opportunity to cure a couple times during testimony, but chose to keep lying about it through deposition, through Pavey hearing. So if we say, okay, it's okay to commit fraud on the court when you're alleging something really serious, how is that deterring this kind of conduct?
Because I think the fact that there's a very serious allegation at issue is connected to the other reasons why we claim that the district court decision to dismiss should be reversed. And that's one of them is that the conduct at issue doesn't connect to the hearing at issue, so that his claim against Dr. Wilson has nothing to do. He wasn't going to benefit from his misconduct in the Dr. Wilson case. I would have trouble standing in front of you and saying he should be able to benefit from his misconduct. That's one issue. The second is the record of Mr. Folks' conduct and litigation other than this. There is none. He is not a serial litigator like there are. We're all aware of that fact. And in fact, several of the published cases dealing with this type of conduct and remedy deal with serial litigators who have repeatedly lied in front of the court. So Mr. Folks, while, again, not defending the conduct, we're not appealing the conduct, this is the first time he's been in this position. And
But how is it an abuse of discretion, which is the standard here, for the court to dismiss this based on the repeated fraud on the court in this particular case? And when I say repeated, I mean he filed the document, he stuck with his story, he lied about it in his deposition, etc.
Yeah, and that's the way the government phrases it. I'm sure Ms. Shields will phrase it here in a minute. But from our viewpoint, it's a continuing one instance, this case. There's not multiple cases or even multiple cases.
But there were opportunities to cure it.
There were.
Which I think is, when I say repeated, that's what I mean. He had various opportunities during the course of this litigation to cure the lie, and yet he chose not to. You might have a different argument if he had submitted the document and then he came clean during his deposition and said, no, I fabricated that, but that's not what happened here.
No, that's not what happened here, and that's not what the record shows. But I do think the fact that he's not, at this point, able to benefit from the fraud, that he has a record of being, I mean, this is a gentleman who's been in prison since 2005, doesn't have a history of committing fraud in the prison grievance system when he's submitted, I think the record shows 85 different grievances over the course of those 23 years. And there is one instance in the record where he's committed anything that's close to what's at issue in this case, and it's just a vague one-sentence reference to lying that is something he was cited for. We don't know if it's lying to a prison official or telling a lie to other prisoners. We don't know what it is. We can't really tell what that is. I think his record is a lot different than other plaintiffs who have found themselves in this situation. I think the critical mass of those three things, plus the fourth issue, which is the severity of the remedy. Now, I don't dispute at all that Judge Hanlon considered. We're not arguing it as a matter of process, that he did exactly what he was supposed to do. He was supposed to look at remedies.
And he says there's nothing else I can do that's really going to have an impact on Mr. Folks. Mr. Folks is on death row. He's about as bad off as you can be.
That's very true. And that factor weighs heavily in one of the suggested remedies we posed, which was this should be resolved in the prison grievance system, because he's a prisoner for life. So things that can be taken from him as part of that enforcement of the grievance process, and the fact that he has now been found to have lied during that grievance process, can take away things that would be very important to someone in his position. Commissary, phones, things like that.
I'm not sure how many of those things he has, by the way. I mean, I have visited that death row. It's pretty Spartan.
And can a court impose sanctions like that, taking away your commissary at the prison? I don't think courts have control and can tell prisons that.
The way we phrase it is they can defer to the prisoner. But I don't think the court could order necessarily.
Right.
There's a due process agreement. But we did point out that in our briefing that their administrative, claim preclusion or issue preclusion would prevent relitigation of the question, especially now that we've been up on appeal, of whether he did in fact alter the document, testify falsely.
Mr. Cranley, you want to save a little rebuttal time?
I do.
Okay.
Thank you for.
Yeah, no problem.
Appreciate it.
You're welcome. Ms. Shields, good afternoon.
Good afternoon, Your Honor. Good afternoon, and may it please the court. Gina Shields on behalf of the appellees in this case. This court has repeatedly recognized that perjury is among the worst kinds of misconduct, and that falsifying evidence to secure a court victory undermines the most basic foundations of our judicial system.
So, Ms. Shields, cutting to the chase, I'm sure you're going to be arguing that Judge Hanlon did not abuse his discretion, even though maybe somebody else might have chosen a lighter penalty. But what I don't want the result of this case to be is for the government to go home and say, oh, well, we don't have to worry about Dr. Watson because, we got him off in this case, and to think that everything was okay without exploring, what actually is going on in the penitentiary at Terre Haute. Because it's one thing to give Mr. Folks a damages award because he was assaulted, allegedly, but let's assume he proved it, that he was assaulted in violation of his personal rights and the prison, the PREA standards and all the rest of it. It's a different thing to say that nobody should pursue that. So I looked into, whether the Bureau of Prisons had internal remedies, an Office of Inspector General, or anything of the sort. And it does seem that there are offices in BOP, because I just don't. The message here, if we were to affirm Judge Hanlon, should not be, oh well, nothing bad happened.
Yes, Your Honor. The BOP does have internal mechanisms to investigate allegations such as this of staff misconduct. As you pointed out, he did fully exhaust his claim before he brought suit, so there was an internal investigation on the remedy.
And there's some concern about spoliation of evidence, these paper towels that sort of get picked up and disappear.
Your Honor, that claim was dismissed by the district court on a motion to dismiss. But to get back to your earlier...
But I'm just saying factually, not, again, sort of from a more institutional point of view. It's not quite the same as Mr. Fulks, bringing that claim. It's different.
Well, there also is the Office of Inspector General. There's an Office of Internal Affairs within the BOP, all of which investigate allegations of staff misconduct such as these.
And is there any reason to think anybody's looking at this, or are they just saying, oh, well, we love Dr. Watson, or what?
Your Honor, we never reached the merit stage at this on that claim. If I'm remembering correctly, I believe there was an internal investigation, but that's not part of the record because we never reached that stage.
Is there anything in the record about whether there were other allegations of sexual abuse against Dr. Watson?
Not to my knowledge. The determined question on this appeal is whether the district court abused its discretion in dismissing all of Mr. Fulks' claims, including his exhausted ones, as a sanction. That means that the mere fact that this court or another district court may have addressed the problem with a different set of solutions or sanctions is not enough. This court can reverse only where no reasonable judge would have done the same. Mr. Fulks has not met that incredibly high burden. And as Your Honors have pointed out, the sanction that the district court imposed is a direct result of the choices that Mr. Fulks made repeatedly throughout the course of this litigation. From the very outset of this case, in July 2020, when the prison officials filed their first substantive filing, they admitted that Mr. Fulks had exhausted his claims of purported sexual assault. It was never the subject of the motion to dismiss or the alternative motion for summary judgment on exhaustion.
Was that claim, by my read of the record, it looks like that claim was headed to trial.
Yeah.
But for the intervening, fraud here.
Exactly, and that was my next point. Absent his egregious misconduct and the perjury and the forgery, that claim would have gone to trial. It would have gone to discovery.
I hope the point you're hearing from the bench is that Warden Watson and they understand the gravity of that claim that would have been headed to trial, and it would have been on full display in a public courtroom, but for this intervening misconduct, and that the BOP, take an allegation like that. I mean, it's a very serious allegation that was dismissed. That looked like it was headed to trial.
Absolutely, Your Honor. We understand that the BOP
And it would have been possible, of course, to have dismissed all of the claims affected by the perjury and allowed the PREA claim to go forward. That would have been a sanction in and of itself with bite for somebody like Mr. Fulks.
If I'm understanding your statement correctly, I don't believe that would be a sanction. Under the PLRA, unexhausted claims have to be dismissed. So if the court only dismissed the unexhausted claims, that's not a sanction. That's just the correct result. That's what.
Well, but you're reasoning backwards, though. I mean, after the fact, once you've determined that they weren't properly exhausted, you're right. I mean, no big deal. But he had filed the claims. He had arguments, presumably, for thinking he could go forward with them. And so, ex ante, to dismiss almost your entire case would seem like a pretty big sanction to a person like Mr. Fulks.
Your Honor, it was a sanction that was proportionate to the misconduct and the waste of time and resources that his conduct caused on the court and the government and the witnesses.
The court wasted no resources on his sexual assault claim.
Your Honor, they wasted resources on his claims that were related to the remedy that he forged. We had an all-day pavy hearing about this.
I understand. There was a cost there.
It was Mr. Falk's own choice in how to respond to the prison officials' invocation and litigation of their exhaustion defense that ultimately led to the dismissal of his exhausted claims. When we first raised the exhaustion defense, Mr. Folks's repeated and willful abuse of the judicial process began, as Judge St. Eve pointed out. He had multiple opportunities throughout this litigation to cure the defect and admit what he was doing and what he had forged. But instead of taking those opportunities, he repeatedly perjured himself and submitted false evidence to the court, first in his declaration to opposing the defendant's summary judgment on exhaustion with the exact purpose of creating a factual dispute that would necessitate a PAVI hearing. And indeed, at that point in reply, the defendants pointed out how the remedy itself reeked of illegitimacy. There's portions whited out, there were lines missing, and in the order on the exhaustion defense, the court found credence and found that our arguments were not without support.
Yeah, nobody's contesting that at this point.
Yes.
Right?
Okay.
So-
Yes, Your Honor. And then he continued to double down on that in his deposition testimony, and also on the PAVI hearing after he sat through our government expert, a forensic document examiner, who testified that the document was forged. He sat through that testimony and then continued to triple down on his perjury and misconduct. Also, I think it's important to note that the court has an interest in both punishing a party's dishonesty and deterring others who might be considering similar misconduct. As this court has recognized, if there are no consequences when that if forgery is uncovered, there'll be far too much perjury and the accuracy of judicial decisions will be degraded. The sanction that the district court chose here not only addressed the substantial waste of time and resources that Mr. Folks's repeated forgery and fabrication of evidence caused, but also will have a deterrent effect on litigants who are considering similar misconduct. If there are no further questions, the question that this court must decide is whether the district court's choice of sanction was arbitrary, given the egregiousness of Mr. Folks' fabrication of evidence, repeated perjury, the substantial waste of time and resources it caused, and the deterrent effect dismissal will have on litigants considering similar misconduct. The district court's decision should be affirmed in all respects. Thank you.
Thank you, Ms. Shields. Mr. Cranley?
Thank you, Your Honor. I really just want to make a couple of brief points. The first one goes to Judge Woods' question about what was the process here. And ultimately, the answer to that question is the Fox Watch that announced, the person policing whether Dr. Wilson actually engaged in misconduct is the prison system itself. And Dr. Wilson is one defendant there, as is the warden. And they looked at it, but the one person who can fully litigate this claim and has the interest in doing so is Mr. Folks. He's the one that has the best opportunity to bring it to light and to litigate it fully. As there needs to be a remedy. Do not dispute at all that there needs to be a remedy. There needs to be a deterrence. All those points Ms. Shields made are correct. This was the wrong one. One of the remedies that would be available that would thread the needle between the two huge public interests here, the public interest in making sure people aren't victims of sexual assault and the public interest in truthfulness before the court, is to say, we're not going to take away the sexual assault claim, but we can put a filing bar on, and we can prevent future litigation, and we can or put a strike on. That takes away a future case. Again, in the briefing, Ms. Shields indicated that, look, that's speculative. We don't know that there's going to be future litigation. Mr. Folks has filed over 85 grievances in his term. It's pretty likely in the time he has left. Sorry, my time's up. But I think it's pretty likely that we will be in that position. And with that, Your Honors, I thank you for your time and your attention today.
Okay, Mr. Cranley, Ms. Shields, thanks to both of you. Mr. Cranley, am I right? You took this case on appointment from the court, right? So you and your firm have our thanks, and we appreciate both counsel. We'll take the appeal under advisement.
Thank you, Your Honor.
You're welcome. Okay, our final argument of the day is in appeal number 231108, the United States versus Hudson. Mr. Drysdale, good afternoon.
Good afternoon, Your Honor. Thank you, and may it please the court. Tom Drysdale, and I'm here today on behalf of the defendant appellant, Javars Hudson. Mr. Hudson was the victim of a shooting on January 23rd, 2022. While receiving medical treatment at a local hospital, a search of Mr. Hudson's mouth revealed a piece of a firearm known as a Glock switch. The question before the court today is whether law enforcement officials provided such significant encouragement that the search must be deemed governmental action. And I think at the outset, there's two important things I want to know. First, there does not have to be an express directive by the police to the private party to conduct the search. And two, even if there is some kind of independent motive from the private party, that alone does not insulate the search if the government provided significant encouragement. So,
But here's my issue with this. I understand that the gunshot wound was in his backside and that the whatever it was, they didn't know at first, was in his mouth. But the doctors treating him figure out pretty quickly that he does have something in his mouth. And you seem to think, well, they should have been utterly indifferent to that because they were just trying to treat the gunshot wound. But they don't come across, in the video or anything, as indifferent. If it had been, for example, a baggie with cocaine in it, people die of that when they break open the bag from chewing on it and ingest too much cocaine. People could be hurt. So it seems to me their repeated efforts to get him to spit out whatever it was they didn't know were medically driven decisions, not because Officer Smith is standing there hanging out at the door of the treatment room.
well, Your Honor, a few points there. I think that there is some questionable medical purpose here in the sense of they of course do seem to want him to spit it out, and there is a statement by the physician at some point of he might get sick.
Well, keeping him stabilized, it's practically a matter of lay knowledge, unfortunately, in today's world. If you swallow too many drugs, you're going to hurt yourself.
Right, and I think our point to that is Mr. Hudson is very clearly awake, alert, making his own decisions, and actually trying to make the decision to not take that medical treatment. And that's where the district court, I think, goes awry a little bit here in saying that his right to refuse...
Not take what medical treatment?
To
spitting it out?
The advice of the medical professionals to spit the object out of his mouth. He's saying no.
But the medical personnel tell him it's more than just to be treated. You have to spit this out because we're concerned it might be drugs. They're saying, we are treating your gunshot wound. We may have to intubate you. We might have to do other things, and you could choke on this, which prevents us from treating you for your gunshot wound.
Your Honor, I think what's happening here is they say, spit it out, or we're not going to treat you. I think that happens. And then what Mr.
Before the officer is involved at all, you hear them start to tell him, spit it out, spit it out,
spit it out. And then what happens is he says, no.
I don't remember they're threatening not to treat him anymore if he won't spit it out. They're trying to explain to him that this could be a serious problem. Right now, it's not a serious problem because it's still in the baggie and so on. But even by the time he spits it out, it's all kind of bloody and a mess.
And I think I misstated it briefly. The threat not to treat him actually comes from the police. The police, Officer Smith busts into the room and says, if you don't spit that out, those doctors are not going to treat you. That's exactly what he says.
Don't you think in the context, though, it's like, look, they can't help you if you don't help them. And the worry, of course, is that he's going to ingest a whole bunch of drugs, right? He, of course, knows he doesn't have drugs in his mouth.
And so he refuses. He refuses
and so
to spit
swallowing a piece of a Glock may not be the healthiest thing to do either. It seems to me.
I can't imagine that it
could have been a lot worse.
Yeah, right.
But I think the fact of the matter is he does refuse to spit it out, and at that point, then the police or the physician then goes to the police, and I think our big point here is that's when there's clearly an evidence collection going on here. The doctor goes straight to the officer and says...
Why is it evidence collection when Smith... I think this is a little weird that Smith keeps saying this, but Smith keeps saying he doesn't care what's in the bag. If it's drugs, he's just going to smoosh it on the floor, he says.
And I think that point actually cuts in our favor. I think that Smith doesn't particularly care that if he's involved in a search or that if a search is going on, because he just wants to get this process going so he can do
He
his
wants to get his
test
gun residue
and
test
get out of
done.
there, which is why I don't think he's terribly concerned with getting a search warrant and conducting a search that he ultimately admits that at least he believes he directed.
Doesn't he say he's not going to charge him for drugs?
He does. Which is why I think he's not concerned with complying with the Fourth Amendment in searching
Why don't
Mr.
we read that as he's not thinking that he's doing a search at all? He's trying to let the medical people do their thing. He wants his gunshot residue test. He's kind of hanging out there waiting for that. But otherwise, they make jokes about whether it's weed or whether it's other things in the bag. But he doesn't really seem to be an officer conducting an investigation of some type.
Well, I think, again, when the physician specifically comes to him and says, look, I think the exact quote is, I told him everything on him is part of a crime scene and he's not cooperating.
Right.
Do you have any ways to convince him? And Smith says, basically, use my authority. Tell him he's not free to leave. And the physician says, perfect. And that's when then you start hearing the medical professionals yelling at Mr. Hudson, saying the cops are not going to leave unless you spit it out. The cops are coming to get you if you don't comply with this directive.
Did he really say, tell him, use my authority, tell him he's not free to leave? I think you're putting a spin on that.
He does say tell him he's not free to leave.
Well, he says, at that point, or is he detained? And he says, yes, he's detained. He's not free to leave.
Correct. That's the quote. He's detained. He's not free to leave. And the physician says, perfect, and goes back and tells Mr. Hudson.
But I don't think the officer directs the physician to tell him that.
He says, he's detained. Is there any ways you have to convince him? That's the question posed to Officer Smith. And in response, he says, he's detained. He's not free to leave. He's answering the question, and then the physician then goes back and uses that authority as a basis to try to get Mr. Hudson to spit the object out of his mouth. And I think that's
But is he doing it at Officer Smith's request? Officer Smith seems to have a single purpose this whole time, which is to get his gunshot residue. And he even makes that comment, of course, at the end that you highlight in your brief. I'm not sure that this can be used. You were my agent. But then he backs off and he says, well, maybe you weren't. We'll have to ask the legal people, or some words to that effect.
I think, to answer your Honor's question, no, there's not a specific request from Officer Smith to go back there and search.
And so then on the implicit side, don't we have also fact-finding by the district court judge, what to make of this series of events as they unfold?
And I think, I don't think there are a lot of factual disputes in this case, because most of it happens to be on camera, whether it be video or audio. And so I think what we're disputing is how those facts apply. And we I think, clearly have a situation here where at some point the physician basically says, I'm not going to be able to get this done for medical purposes. Let's see if I can get this done for evidence collection purposes in conjunction with the police. And I think that's the main point we're trying to articulate here. And if there's no other questions, I'd like to save some time for rebuttal.
Yeah, absolutely. Very well.
Thank you, Your Honors.
Mr. Canestra, go right ahead.
May it please the court. Good afternoon, Your Honors. Jeff Kinstra, excuse me, on behalf of the United States. There is an obvious medical purpose, as Your Honors have already recognized, in ensuring that a shooting victim doesn't have a foreign object in his mouth that could either obstruct his breathing or cause him to overdose on whatever substances may be inside that object. The defendant's refusal to spit that object out doesn't mean that those medical purposes go away, such that at that point the medical providers shift their purpose elsewhere. It's exactly the opposite. As long as that object is in the defendant's mouth, the risk of overdose and the risk of choking remain in full effect. And so, as the video shows, the medical personnel throughout the encounter remained focused on those medical interests and ensuring that the defendant did not become sick from whatever was in his mouth, that he didn't choke and that he didn't overdose. The fact that the medical personnel did have the independent medical purpose is itself dispositive when it comes to agency. The cases that the defendant relies on, in the contrary, especially in the reply brief, cases like Korngold and Byers and Lustig, where they're referring to the independent the private party's independent motivation, that's language talking about joint participation. So in those cases, the government actors engaged in actually conducting the search side by side with the private parties. And so sensibly enough, those cases recognize that the fact that the private parties are engaging in the same conduct for their purposes doesn't insulate the officer from their actual conduct in actually opening the parcels in some of the cases, or actually entering the areas to be searched and selecting what evidence to select, or identifying what evidence to collect. But when it comes to agency, the party's independent motivation is dispositive. It shows that they're not acting on behalf of the officer, they're instead acting on their own behalf to pursue their own ends. And as the Ninth Circuit decision in Cleveland, which the defendant relies on, that case acknowledges that when it comes to agency, the party's independent motivation is dispositive, and that this court has repeatedly recognized that as well in cases like Shaheed and others.
So that just takes the Fourth Amendment out of the picture from the get-go, then, if we were to adopt that viewpoint. We wouldn't have to worry about destruction of evidence, we wouldn't have to worry about inevitable discovery, we wouldn't have to worry about all the rest of those doctrines, some of which are a better fit for these facts than others.
That's correct. The parties, or the medical provider's independent motivation is itself dispositive as to agency, which then is dispositive as to the motion to suppress.
Whether it was state action
That's
doing
correct.
the search at all, yeah.
The other side...
Are you taking the position that we're evaluating this de novo, or do we owe any deference to Judge Shadid's read of the video and the rest of the evidence?
This court's review is only for clear error. It is not de novo. The district court did make factual findings on pages
even after Scott versus Harris, where we can just look at the video?
Yeah.
So I take your point there. The video shows what the exchange was, but what inferences to draw from that video as to what the parties intended, what if something was implied or expressed, those sorts of inferences are factual findings that this court would owe deference, and the court did make those factual findings. On page 5 to 6 of its order, it said that there was no inducement here. That factual finding certainly wasn't clearly erroneous. It also made a factual finding as to the medical personnel's intent that at all times they were pursuing their independent medical purpose.
What about the ultimate determination that he wasn't acting as a government's agent? What standard do we review that under?
I believe that would be de novo after taking the factual findings as granted, assuming that they're not.
There seems to be a
erroneous.
little bit of inconsistency if that's de novo or abuse of discretion, that ultimate determination.
That may be. I'm not sure exactly what Your Honor is referring to there, but typically the standard review that's going to apply in motions like this is that the legal conclusions are reviewed de novo, but any of the underlying facts are reviewed for clear error. And so that's the standard of review that we've argued for here. The defendant makes much here today and in the brief as well about the medical personnel using the police presence to further their private purpose. And I think that's a fair characterization. They are using the police presence to further their private purpose of getting the defendant to spit out the object. But in that respect, that's really no different from cases like Shaheed with the mall security guards, where in those cases, the private actors absolutely use the police presence to further their private purpose. Their private purpose in that case is to deter shoplifting and to hold shoplifters accountable. And they do that in part by calling the police and getting the police to come and arrest the people while they're in their custody. And so those cases really wouldn't be any different if the officer or the security guards in those cases said to the person, which they very well might have, something like, I've already called the police, they're on your way, they're going to arrest you when you get here, so don't get any ideas about trying to leave or anything like that. And so in that circumstance, the private party has used the police to further their independent purpose, but because they are still seeking their own independent purpose, and that sufficiently motivates their conduct, they're not acting as an agent, and so their conduct isn't attributable to the police.
So that's your response to Mr. Drysdale's point about the pressure or the intensity of this kind of ratcheted up when Officer Smith told the physician that, yeah, he's not free to leave, he's detained, and then went back into the treatment room, and they leaned on Hudson a little bit more to spit that out.
Exactly right. So at that point, the officer could be responsible for his own response. For example, if the defendant had argued that at that point it became an unlawful seizure and that the officer is responsible for conveying that the defendant was detained, That's not a theory that he's made in this case, and it wouldn't succeed. But the fact that at that point that the doctor is using the officer's presence to further his own independent medical purpose does not make the doctor an agent.
Yeah, you think it's factually relevant. One thing that stood out to me is that at all points in time, Smith remains outside the room. Now, there's no question that he's saying things and commenting, and nobody's arguing that Hudson is outside of earshot or something like that. But this, that maybe this is different if in that last encounter, Smith, hauls into the room and right next to the treatment center said, look, or treatment table says, I've had it. Thing out of your mouth right now. Nothing like that happened.
That's correct. It didn't happen. So
he stays back a little bit the whole time, and the people that are directly interacting with him are the medical team.
That's exactly right. And so the officer's outside the treatment room. Once the doctor closes the curtain in his face, he's outside of the defendant's view. The doctor or the officer never suggests to the medical personnel that they should do something on his behalf. Doesn't suggest any reward or benefit or any detriment for not acting. So really the officer stayed out of the way. The one thing that he did ask for was to be able to perform a gunshot residue test at the appropriate time. But he made equally clear there that he wasn't asking them to work on his behalf, that he was going to stay out of their way, that they should do their thing first. And all he wanted was, when it wouldn't be in their way, that he would perform his own test on his own behalf. And so
and that seemed to be his overarching purpose, right? I mean, this
Yeah,
this
he
is
mentions it
didn't it start with
repeatedly.
a bar shooting or restaurant shooting or something?
Yeah, there was a shooting outside of a nightclub in
Yeah.
Bloomington. About 2 a.m. I'm happy to answer any questions your honors may have on the emergency aid exception or the evidence destruction issue. Otherwise, we'd rest on our briefs on those and ask this court to affirm.
Okay, very well. Mr. Drysdale, I know you had some time left.
Just briefly, Judge St. Eve, to answer your question, I think the ultimate question is indeed reviewed de novo. I think Babris settled that for the most part. I know there was some confusion in the law prior to that, but I think that's the most recent opinion that settles that question. Yes. Your Honors, I want to make it clear, to the best of my knowledge, this court has never held in any of the cases that the government cites in their brief that the Fourth Amendment just simply goes away regardless of the police involvement, just because there is some type of independent motive. All the cases they cite in their brief, Shaheed, Koenig, Ginglin, Crowley, not a single one of those cases involves the police being present while the search was taking place. None of them involve that. They do not involve the private party kind of bouncing back and forth and consulting with the police in the middle of an ongoing search. So all of those cases fail for that particular reason. And Judge Scudder, just briefly to your point, I'm not sure that I agree that at all points in time Officer Smith stayed outside of the room. As soon as something was discovered in Mr. Hudson's mouth, that is when Officer Smith went back in the room after already being dismissed one time, reasserted his authority, and started yelling at Mr. Hudson. So he was indeed back in the room after it was determined that something was in his mouth.
Yeah, I mean, I think your point, Mr. Drysdale, is a fair one about the more kind of interactive, the back and forth, and that's what distinguishes this case from others that have come before it, and we'll have to sort it out.
And that's precisely right, Your Honor. And that is where we would assert that there is government action in this case. Thank you, Your Honors.
You're quite welcome. Mr. Canestra, thanks to you. We'll take that appeal under advisement, and the court will be in recess.